Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. A cupcake sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hang on. Hey, good morning. Good morning. We are starting early today because we have got a bombshell. We've got a bombshell and we're going to read it. You want to play? Let's play. You want to go? Let's go. All right. I've got the memorandum of law in opposition to the Commonwealth's motion on third-party culprit with the evidence for each of the third-party culprits that were named in court last week. Brian Albert, Brian Higgins, and Colin Albert. Let's go. Because this is supposed to start at 11 and we have a little bit of time. And so we're going to read what we can before the hearing starts. Let's go. This is docket number 625. Docket number 625. Here we go. You want to know about third-party culprit? We're going to tell you. Here it is, laid out. If you have any friends who don't know anything about this case and want a little bit of a summary about what's going on with this case, send them to this document. Send them here. Now comes the defendant, Karen Reed, and respectfully request that this honorable court deny the Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. The third-party culprit evidence Ms. Reed intends to introduce at trial meets the relevant admissibility standards, and as such, she's constitutionally entitled to present it at trial to the jury by virtue of the Due Process Clause of the United States Constitution. See the 14th Amendment. Contrary to the Commonwealth's suggestion in its motion, there are no requirements that the defense name a single third-party culprit or prove that the alleged third-party culprit committed all of the alleged offenses exactly as charged. And even if Ms. Reed were not entitled to introduce such evidence as part of a third-party culprit defense, the proffered evidence the proffered evidence meets the standards of admissibility for Bowdoin evidence and is thus admissible for purposes of establishing the inadequacy of the police investigation. Accordingly, the Commonwealth's motion must be denied. Here you go. Here's the relevant facts regarding third-party culprits. The defense has announced 3 potential third-party culprits in this matter. There's evidence that each of them had the motive, intent, and opportunity to commit the crime. All of them were present at the scene of the crime on the night in question. Brian Albert. Brian Albert did not have a good reputation among his fellow police officers. He was known as a bully, someone who has a history of sucker punching fellow officers, particularly when he was drinking. We saw 2 of them on the witness list for the defense. He has been investigated by the Boston Police Department's Internal Affairs Division for his violent conduct in that regard. Albert is a trained boxer, and several of his fellow officers were afraid of him. I did not know that there had been internal investigations done on Brian Albert, but that's interesting new information for me. I don't know if you knew, but I didn't know. Brian Albert was present at the scene of John O'Keefe's death on January 29th, 2022. John O'Keefe's lifeless body was found on Brian Albert's front lawn, just feet from his front door and the door to his garage. Brian Albert admits to having been home at all relevant times. The evidence, including computer forensic data, overwhelmingly establishes that John O'Keefe entered Brian Albert's house. So they've got more receipts, and they're going to be able to prove that John O'Keefe went in the house. Game on. Brian Albert was drinking heavily throughout the day and night in question. Brian Albert spent the day and night with Brian Higgins. In the weeks leading up to John O'Keefe's death, Brian Higgins had demonstrated a romantic interest in Ms. Reed, Mr. O'Keefe's girlfriend, but he had been rebuffed, essentially ghosted. And on this night, Higgins was confronted with Mr. O'Keefe and Ms. Reed together and clearly happy. Higgins' words and deeds revealed significant aggravation. There must be a ghost emoji somewhere. Let's see it in the chat. Brian Higgins was in the Brian Albert's home when John O'Keefe entered. After a period of time, Brian Higgins left the Albert residence, but maintained contact with Brian Albert. There were suspicious and unexplained phone calls between the two of them at 2:22 a.m. on January 29th, 2022, not long after Mr. O'Keefe was mortally attacked. Mr. O'Keefe had injuries and wounds on his right arm from an animal or dog attack. Brian Albert had a large German Shepherd at the location on the night of the attack, a German Shepherd that indisputably had a history of violent dog and human attacks in the past. We've got witnesses on the witness list who were attacked by Chloe prior to John O'Keefe's murder. This aggressive and violent German Shepherd was, according to Brian Albert, not good with strangers. And he did. He testified to that on the stand, remember? We were there. None of this evidence was investigated by the police in charge of this case. In fact, the evidence shows that was by design. Ex-trooper Michael Proctor was asked in a text exchange whether the homeowner Brian Albert would catch grief as a result of having a dead body of a police officer on his front yard. Michael Proctor's response demonstrated his intent to protect a fellow police officer. Nope. The homeowner is a Boston cop too, verifying his intent to give a pass to Brian Albert. There is also consciousness of guilt evidence implicating Brian Albert. Despite a massive police presence on his front lawn, just feet from his bedroom window, Brian Albert never came out of the house to speak with or interact with other first responders. It's worth noting that Brian Albert was at all times a first responder himself, yet he chose to ignore his duty to help someone in need in favor of remaining secure in his home, away from those who might question him or his family. Further, after John O'Keefe's death and after the defense publicly raised the specter of a German Shepherd attack in open court, Brian Albert's German Shepherd was rehomed. And it was shortly after they talked about Chloe in court that Chloe was rehomed. Brian Albert essentially jettisoned a longtime member of his family to another state, out of the reach of investigation, out of the reach of the defense. Any reasonable investigation would have seized upon the combination of this suspicious conduct in furtherance of a fulsome investigation into the death of John O'Keefe. Next, Brian Higgins. Like Brian Albert, Brian Higgins was at the scene of the crime on the night in question. Brian Higgins was at Brian Albert's house at the same time that John O'Keefe arrived and went into the house. Brian Higgins had been engaged in a flirtatious text message exchange with Ms. Reed in the weeks leading up to January 29th of 2022. He had testified that Ms. Reed had kissed him after he watched an NFL playoff game with her and others not long before January 29th. He testified that Ms. Reed visited him at his apartment after that, but Higgins acknowledged that the text message flirtation and all contact between them ended, and that Ms. Reed was the one to end it. She stopped responding to him. She no longer gave him any attention. This was after Higgins indicated in multiple text messages that he was interested in her and found her attractive. On January 28th, 2022, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe walking into a bar together, getting along, and in the words of at least one witness, acting lovey-dovey. Ms. Reed and Mr. O'Keefe were affectionate with each other that night. Brian Higgins was there with Brian Alberts watching it. Higgins' annoyance and irritation were reflected in a sarcastic text he sent to her while she and John were merely feet away from him. Well, there is evidence that Mr. Higgins wanted to lure Mr. O'Keefe into the Albert residence. At the waterfall, minutes before he leaves, Higgins motions to Mr. O'Keefe, then follows up with a text message to make sure he would be going there. Higgins went inside Brian Albert's home. John O'Keefe also went inside. There is evidence, therefore, that Higgins had the motive, intent, and opportunity to cause harm to John O'Keefe. The fan is off. The fan is up on Court TV, but it's not spinning today. This is important, so I want to read it before we start the hearing. Even if it starts, we may be a couple of seconds late, so please just be patient because we need to hear this before the arguments. Like with Brian Albert, there is also evidence of Higgins' consciousness of guilt. For example, after a long day of drinking and driving, Higgins did not go home after he left the Albert residence that night. Instead, he went to the Canton police station. He initially claimed that he went there to do some administrative work, but later changed his story to going there to move his vehicle. He was consistent, however, about the fact that he never called anyone on the phone while there. This turned out to be false. Video evidence undisclosed to the defense during the first trial establishes that Higgins made a phone call while he was at the Canton police station at 1:40 a.m. He has not revealed who he called. Given that the evidence was not timely disclosed, the defense did not have an opportunity to confront Higgins about that fact. When Higgins went home after that, he still did not go to sleep right away. At 2:22 a.m., he speaks by phone with Brian Albert. He tried to claim that the phone records reflected a butt dial and apparently a butt answer, taking Albert and Higgins' testimony together. This 22-second phone call, however, is further evidence of consciousness of guilt. When Higgins realized that the defense was interested in seeing the contents of his phone, a defense motion had been filed, he further demonstrated consciousness of guilt by getting rid of his phone and his SIM card. The manner in which he disposed of it, however, was extraordinary and showed how intent he was on keeping the information from his phone out of the hands of the defense. He destroyed the SIM card and then traveled to a military base to put that tiny object, about the size of a thumbnail, into a large dumpster. Higgins' conduct on the night in question and following establishes clear evidence that should have been investigated during the course of this investigation, but which evidence was ignored by Michael Proctor and his supervisors. Next up, Colin Albert, depending on who you listen to. Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to January 29th, 2022. Colin had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off to his face. Colin Albert testified under oath that he had never been in a fight in his life, yet there was video evidence of him taunting others to fight, desperate for violence. Colin Albert, after John O'Keefe's death, was photographed with his knuckles scraped, consistent with injuries that would be suffered during a physical altercation. He was prepped on that too. Remember what he said? His story was that he had a beer in his hand and he slipped on ice in a driveway and he put his fist out like this, and scraped his knuckles. Yeah, that's it. That's the ticket. He was prepped with his impeachment testimony. Those are my words, not defense counsel's words. Colin Albert's name was purposefully omitted from any police reports. There was no indication in any of the reports provided to the defense in the first months of this investigation that Colin Albert was anywhere near 34 Fairview Road, his uncle's house, on January 29th of 2022. In fact, there was no indication in those police reports that Colin Albert even existed. It was not until the defense sent a letter to the prosecution while the case was pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness, that the Commonwealth finally produced information that Colin Albert was indeed present at Brian Albert's home on the night in question. It is a reasonable inference from the evidence, finally, and perhaps grudgingly, provided to the defense, that Colin Albert's name was intentionally omitted from the police reports in order to protect him. Similarly, Brian Albert is the only person listed in the initial report whose first name was not spelled out. He is just listed as B. Albert. Oh my gosh, I've pointed that out so many times. I feel like I'm being heard. And the number of his home is misstated on various first responder reports. Remember, it was 34 Fairview and then it was 32 Fairview. The initial call, I think, went out to go to 32 Fairview. One second, I'm getting patched. Oops. Those myriad mistakes are more than simply curious. They are systematic. They are systemic in this investigation. There appeared to be a conscious effort of the investigators of this case to hide these third-party culprits from the defense and the public. Argument. The defense is entitled to raise a third-party culprit defense. The Commonwealth's suggestion that the defense has the burden to name a single person for purposes of a third-party culprit defense is incorrect and misstates the law. Likewise, the Commonwealth's claim that the defense must prove, quote, that another individual had the motive, intent, and opportunity to commit not only murder, but vehicular manslaughter and leaving the scene, which the Commonwealth apparently says in their motion at page 3, is also incorrect and unsupported by case law. Are you shocked? Third-party culprit evidence is a time-honored method of defending against a criminal charge. According to Commonwealth v. Rosa, a defendant may introduce evidence that tends to show that another person committed the crime or had the motive, intent, and opportunity to commit it, citing some cases. Defendants have a fundamental due process right to present such third-party culprit evidence, and accordingly are given wide latitude to the admission of relevant evidence that a person other than the defendant may have committed the crime charged. If the evidence is of substantial probative value and will not tend to prejudice or confuse, all doubt should be resolved in favor of admissibility. According to Commonwealth v. Conkey, which is a case from 2004, quoting Commonwealth v. Kaiser, a 1979 case. Of course, while defendants are entitled to wide latitude in introducing third-party culprit evidence, there are some constraints on what evidence can be introduced. Most fundamentally, the evidence must be relevant. That is, it must have a rational tendency to prove the issue raised by the defense and cannot be too remote or too speculative. Still, the bar for admissibility is generally low, and again, all doubts should be resolved in favor of admissibility. And then they go on to cite some more cases. Cases in which the court find that such evidence should be excluded, including the cases that the Commonwealth cites in its motion, involve evidence that is irrelevant, very minimally probative, purely speculative, or some combination thereof, and therefore unlike the instant case. Notably, none of the constraints on the admissibility of third-party culprit evidence pertain to defendants' ability to raise third-party culprit evidence or arguments as to multiple third parties. The Massachusetts Guide to Evidence and the cases addressing this issue make no suggestion, implicitly or explicitly, that defendants are prohibited from naming multiple third parties or that they must name a single third-party culprit. In fact, in cases where the defense argues that multiple third parties may be responsible, courts have implicitly blessed third-party culprit defenses involving multiple third parties by engaging in full-throated, where's AJ's full-throated motion? Somebody has that username. Full-throated, this is why I got to highlight it because I keep losing my place. Full-throated analyses of the admissibility of the evidence as to each third party. In Commonwealth v. Rule, which the Commonwealth cites, of course they do, in discussing the admissibility of hearsay, see page 4 of their motion, the defendants sought to admit, and the trial court excluded third-party culprit evidence regarding 4 individuals who could have committed the crimes charged alone or together. The appellate court, in turn, engages in a full and detailed analysis of the third-party culprit evidence admitted and excluded as to each of the 4 third parties. The court nowhere in its opinion makes any suggestion, even in dicta, that the trial court was wrong to admit evidence as to multiple third parties, despite the fact that the court was well positioned in this case to address the matter, and the SJC denied cert. Fan is still up. Nothing is happening in court yet. In Commonwealth v. Finney, which, as you may recall, was actually David Yannetti's case, right? Commonwealth v. Finney, P-H-I-N-N-E-Y. A young woman was murdered in her own bed. The prosecution charged the defendant, her next-door neighbor, with the crime. The defendant had signed a written confession that he had entered her residence while she was sleeping to take photos of her lying nude in bed, then bashed her over the head with his camera when she woke up. Defense counsel in that case pursued a third-party culprit defense, which amounted to pointing to 2 unidentified men in downtown Lowell, one with blood on his t-shirt, who asked a motorist for a ride to a hospital, an unidentified man who was the victim's roommates, who was with the victim's roommates, and who was seen arguing with the victim outside her apartment. One sec. Somebody said, God save the fan, the Commonwealth can burn. Distractors, hyperbole, and flummoxification. Clearly, by admitting that scant evidence of potential third-party culprits, none of whom were identified at or near the scene of the murder on the night in question, the trial judge was following the SJC's longstanding guidance that all doubts should be resolved in favor of admissibility. Claw 102. That's so lol. Lol. Despite defense court's pursuit of multiple third-party culprits as the targets of his defense, however, the SJC nonetheless reversed the conviction on the basis of ineffective assistance of counsel because defense counsel had failed to point to a fourth third-party culprit. Oh, well, that's interesting. That additional third-party culprit in that case, number one, lived down the street from the victim. Number two, made derogatory comments to his wife about how the victim wasn't the goody two-shoes the media had made her out to be, and how she probably deserved to die. And number three, came home at 4 a.m. and washed his clothes the night of the murder. And four, apparently got rid of an axe handle he used to carry in his car shortly after the murder. This is fun case law. This is so fun, Bentley. This is fun case law. The Supreme Judicial Court ruled in that case that it was ineffective assistance of counsel that trial counsel did not raise a third-party culprit defense regarding that individual. In fact, the SJC found that on the basis of the above evidence, there were substantial connecting links to the murder sufficient to justify the admission of hearsay to support that defense. Notably, unlike the case at bar, there was no witness who identified the third-party culprit in Finney as having been at the murder scene on the night in question. Similarly, in Commonwealth v. Conkey, Supra, a woman was also killed in her own home. I don't know if she'll rule on the motion to dismiss today. I don't know. My inbox is open if it comes in. Absolutely, I'm more of a Alessi. I will allow it. Can we take a second and bow to Melanie's freaking quick wit? I'm an acquired taste. You love me or you hate me. There's really no middle ground there. Similarly, a woman in Conkey, a woman was also killed in her own home. The defendant lived on the same street a few doors away. The defendant was an admitted burglar who liked the challenge of breaking into homes when they were occupied. His fingerprint and palm print were found on the victim's bedroom door. He admitted to having been in the victim's home on the night in question, but insisted that she was already dead when he got there. Trial counsel pursued a third-party culprit defense, accusing the victim's landlord, who also lived 6 houses away on the same street. The victim had rebuffed his invitations to go out on a date. The landlord admitted to having been in the victim's home a few days before the murder to do some repairs she had requested. The landlord asked the police if the victim had been strangled with a nylon stocking, which she had been, when that fact was not yet public. The trial court allowed the above evidence about the landlords to support the defendant's third-party culprit defense. The SJC nevertheless reversed the conviction, ruling that the trial judge should have also admitted evidence of unrelated past sexual assaults committed by the landlord, including one that took place several years before the victim's murder. Wow. Imagine allowing in all kinds of evidence when here they have been just blindsided at every turn and nothing's allowed in, and you can't even state the grounds for your objections. None of the constraints on a third-party culprit defense include a requirement that the defense prove that the third party committed all of the alleged offenses as charged. And how could that even be? Like, that's ridiculous. Because in this case, for example, John O'Keefe was not hit by a car. The defense should not have the burden to show that someone else hit John O'Keefe with a car, because that's not how it happened, because physics, injury, science, dog. The defense is permitted, as here, to offer third-party evidence as to a single charge without necessarily addressing the other charges. The proffered evidence need only be relevant to one of the allegations. The third-party culprit defense is a way of defending against a criminal charge, and thus may be raised as a single criminal charge when multiple charges are alleged. All right, no sound up yet on Court TV. So we haven't missed a thing. And look, we're well, let's see, this is 16 pages, and we're only on page 12, but you get the gist, right? You get the gist. Now we know who the third-party culprits are, and we know their motive and their means and their opportunity. The courts have reasoned that judges should consider whether feeble third-party evidence diverts jurors' attention away from the defense so greatly as to outweigh the reasons in favor of admission. But the evidence the defense seeks to offer in this case is the opposite of feeble. Oh, what's a word for opposite? What's a good word for a synonym for opposite of feeble? The defense offered in the first trial and intends to offer in the second trial robust evidence of motive, intent, and opportunity of potential third-party culprits. Massachusetts courts recognize and accept a necessary consequence of a defendant's assertion of their constitutional right to introduce third-party culprit evidence that meets the admissibility standards. Some diversion of jurors' attention away from the defendant and onto the third party. It is to some extent an inevitable part of the third-party culprit defense. And in any event, in all cases where third-party culprit evidence is of substantial probative value and will not tend to prejudice or confuse, all doubts should be resolved in favor of admissibility. Yeah, let this stuff in instead of trying to keep everything out. Weasel. This is one such case. Accordingly, contrary to the Commonwealth's claims, the evidence the defense seeks to introduce is admissible as third-party culprit evidence. Point B, the evidence is also admissible for purposes of a Bowden defense. Remember, the Bowden defense is that the investigation was so crappy, so lame, so inept, so ridiculously, unbelievably poor, piss poor, that you couldn't possibly find my client guilty based on the lack of an investigation alone. And they go on to say, in any event, evidence that does not qualify as third-party culprit evidence may nonetheless be admissible as Bowden evidence. Bowden evidence is evidence offered to establish the inadequacy of a police investigation. Under Massachusetts Guide to Evidence 1107, evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated, in circumstances in which it was reasonable to expect that the police should have conducted such tests, followed such procedures, or investigated such information, is admissible. There's also the reason that I think that Michael Easter, who is the FBI retired special agent, whom the defense wants to call in to talk about proper investigative techniques and maybe geofencing, should be allowed to testify. Such evidence can be used by the defense to argue the deficiencies or omissions in the police investigation create a reasonable doubt as to the defendant's guilt. The standard for admissibility in the Bowden context is even more liberal than in the third-party culprit context. Once determined to be relevant, Bowden evidence is admissible unless its probative value. Back to one. Once determined to be relevant, Bowden evidence is admissible unless its probative value is substantially outweighed by its prejudicial effect. Yeah, Court TV is live, but it's not. They're not in court yet. I'm looking at the fan. You're saying that it's on, but I have it up and I don't see it on. YouTube must be a couple of seconds behind. All right, we may need to adjust the volume, so just hang tight for a second. Maybe you want to put on your volume, Court TV. Really? Yeah, it's already morning break time. Why is there sound? Let's see if we can find a feed that has their sound up. They're sleeping on the job. God save us from the Commonwealth, please. Here's who has their sound up. WCVB Channel 5. It might even be a little bit better. We'll try it.
Before we begin, Mr.
Here we go.
ABC, Judge 22117, Culprit versus Karen Reed. Can I have help identify themselves, done?
Good morning, Your Honor. Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mrs. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Judge. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Mr. All right, so before we begin, Mr. Jackson, when we left the other day, when we were talking about Michael Easter, I gave you the opportunity to get some authority on expert testimony and voter defense. Were you able to do that?
We were.
Do you have something to file?
Yes, it was filed yesterday. I do have a courtesy copy of this one.
Okay.
And I can, if the court wishes, we
No,
can take that on.
that's,
That's gonna suffice.
I think so. I'll take a look at it.
It's got everything in it that I would say orally anyway, but if the court has any questions, I'm happy to answer any questions.
All right. Thank you. All right, so thank you. So similarly, regarding the third-party culprit argument the other day, Mr. Yannetti, I see you did file something late yesterday, so I got that. I'm just wondering if either the Commonwealth or the defendant want to be heard on that.
Yeah, let's hear it. Let's hear it.
Commonwealth does.
Okay, so I'll hear you, Mr. Brennan.
Here we go. Third party culprit. Exactly what we were just reading. We were reading the opposition. Be prepared to be enraged
Your
by the
Honor
weasel.
asked for a proffer from the defense regarding third-party culprit. Alternatively, evidence that would be separate regarding third-party culprit aspect of Bowden. We received some information from the defense that does not distinguish whether their intention is that it applies to third-party culprit or whether it applies to a third-party culprit aspect of Bowden. Those concepts are logically and legally distinct. Regardless, when you look at the proffer by the defense, it is insufficient and inadequate for both third-party culprit and for any third-party culprit aspect of Bowden.
I don't think I've ever read better third-party culprit evidence and consciousness of guilt evidence on behalf of 3 suspects than I just read to you. Was he not there for the first trial? All of this stuff was testified to by these exact third-party culprits. We know you didn't watch the trial. We know you weren't there, but give me a break. This is the weakest argument. This is how you're going to start off the day? Good luck to you, sir. Brother, good luck to you, my brother.
But the evidence is equally feeble for both.
Feeble.
Relative to third-party culprit evidence, there are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit evidence. Not to iterate the law because it is clear, but there must be relevance, there must be a substantial nexus between the claims of the defense and the third-party culprit theory. They provided 3 people that they identify as third-party culprits. It's helpful just for a quick synopsis of the history. In this case, prior to the first trial, the defense never identified a third-party culprit. At some point, the defendant herself said that they knew who the third-party culprit was, and recently, the position of the defense has shifted that they don't know and don't need to know. Now, the law accommodates specifically identifying somebody. It also accommodates general, but it has to have specificity in the complaint. There has to be a motive, an opportunity, and an intention. There has to be evidence that draws the correlation.
I'm sorry. Did you read the papers? Did you read the papers? Scott, I know that you're here, so if people are complaining about the volume or you think the volume is bad, just text me, please, and I will lower my volume. But there's a lot of trolls who come in and complain about the volume to disrupt the stream, which is happening right now. So I guess they didn't read the papers.
Can't be bad character, speculative, or just putting out information that's negative towards a witness so that that can backdoor prior bad acts against a witness and be used for a different purpose.
Like an internal affairs
They
investigation?
identified one person, Colin Albert. And in their proffer, what they offer, number one, and it's important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up to January 29, 2022. Now, other than maybe on social media or in interviews with the defendant in national broadcast, there's no evidence of that. There was no evidence that's going to be admitted at this trial that shows there was a feud between Colin Albert and John O'Keefe. There is no evidence that there was any hostility between Colin Albert and John O'Keefe.
I'm sorry, have you looked at the witness list or the witless list as we're calling it? Look at Kelly Reed's face. First of all, Kelly, you look gorgeous today. Gorgeous. And there she is in the back row. Look at her face. Let's just watch Kelly.
No evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence of any motive, of any intention, or of any opportunity whatsoever. In fact, the evidence is that Colin Albert was not even at 34 Fairview at the time John O'Keefe arrived there on January 29, 2022.
Oh, so he did arrive
And so
there.
simply saying
Lies, lies, lies. Yeah. My volume is a little loud. Okay, thank you, Scott. Thank you, Scott.
it is not evidence. And an attorney should not be allowed to confront a witness about an allegation that has no factual basis for them to then have to defend the accusation. The prejudice then seeps to the jury, and the Commonwealth is in the position of having to disprove a claim that had no basis to begin with. The second claim that they make regarding Colin Albert is that he had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face. There is no basis for those claims. There is no witness for those claims. There's no information.
Again, okay, is that better now? Is my volume better now? I'll try and speak softly and carry a big stick today. They must have evidence of it or they wouldn't be talking about it. And he also did lie on the stand and said he was never involved in a fight in his life. And then there was the bang, bang, pull up biatch video. So, you know, there's that.
Regarding those claims. I understand there may have been a party where there was beer cans, but there was no Colin Albert. So to attribute a situation or an incident to him, the defense would need some good faith proof, actual proof.
Who told you that? Julie Albert or Chris Albert? Because they were in contact with Michael Marcy's office and telling him to make that hostage statement saying that Colin Albert was never in the house and that Colin Albert is not a murderer.
Fact that this actually happened. And there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof is because it didn't happen. So again, the defense asks for an invitation to simply cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor and the government has to disprove it. That is not the cloth that third-party culprit is made from. Regarding the suggestion that there was some type of feud or tough relationship, I saw on a video that there were two radio personalities, and I have the clip, who spoke and met with Karen Reed. And during the conversations, at least they relayed that there was some claims about a drug issue. And according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything.
What two radio personalities interviewed Karen? Anybody know?
And so what we know is there is no history of animosity between Colin Albert and John O'Keefe.
Because
We know
Julie
that
Albert
there
said
was
so.
no animosity between his family and John O'Keefe. The only event known is that at some point, Colin Albert's younger brother ran across John's lawn. Mr. O'Keefe supposedly yelled at him and then bought him candy as an apology. That's it. So we have an alleged third-party culprit, a very strong claim, with no evidence, no motive, no opportunity, not even present at the time that this alleged collision occurred. And so in that absence of evidence, it's not even feasible. Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility. Really, it seemed to be a backdoor way to tarnish his reputation.
Oh,
And
here we
then-
go. Defending the Albert reputation again. Wow. Just wow. Remember also maybe just Colin Albert likes to get in fights. Maybe like someone else started it and he just wanted to get a couple of punches in because, you know, bang, bang, pull up, bitch. He didn't even know those guys he made those videos about, right? It was an opposing, like a hockey team from another town. There doesn't need to be a motive for drunk people that want to get in fights. They just do.
Bind him with other people the defense would like to attack to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped, and inevitably it turns out that picture, I think the exhibits were introduced at trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had
Can somebody in the chat with experience tell me how long it would take those knuckles to heal? Just curious.
scraped knuckles subsequently, because he may have done a video that some use would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce alleged aggression or prior bad acts, but there's no bind whatsoever. The second person that the defense.
Well,
would
before
like
we move on to the second
identify as
person,
a
let's
third
talk about why everyone lied about Colin Albert ever being there. Why is he left off of every police report? Doesn't that point to something? And they're going to have, apparently the Beatties are on the witness list. And apparently Colin called Erin Beatty at 12:33 asking for a ride. She didn't answer the phone. So there's that.
party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it. And even if it was so, has nothing to do with this case. Known as a bully. So rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing.
How about the two unknown male contributors to the DNA of the red-brown stains found on John O'Keefe's shirt, I think, and jeans? How about the two unknown male contributors of DNA? How about we test for that? How about everybody comes in and does a buccal swab and we find out who those two unknown male contributors of DNA were? Because I've got questions and I need to know why the Commonwealth never tested those two unknown contributors. Don't you want to know?
They suggest, and I'm not sure what the basis for this is, that he was drinking heavily that day when he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just general inflammatory accusations about character. They say he was a trained boxer because when he worked out, he boxed and he was engaged in charity events, some dating back to 2003.
Mhm.
By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general.
Anybody watch Boston's Finest? He was on a reality show called Boston's Finest. He's a tough guy. There are two witnesses that are going to come in and say that he sucker punched them. Or maybe one was a witness to his sucker punching of the others at like a Christmas party or something, and then there was also an internal affairs investigation against him for, being violent, maybe, because we read the papers.
Suggestion of strength and distorted into a hopefully perceived sense of violence that it has no root at all, no root. They went as far to say he was investigated by BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There is no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact. I'll say, even though it is off base entirely, it has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't.
Well, yes, exactly. And a hothead might get in a fight just because they want to fight. And yes, I think that could factor in here. Don't you think the jury might want to hear about that? It doesn't matter that his internal affairs investigation was not about John O'Keefe. It's not the standard, hon.
They don't do it very well because they provide no details. These are all just general accusations by the defense. In fact, I would say it's not important or admissible. You can't bolster the good character of a witness, but to simply make suggestions of bad character is not any root or tethering to this case specifically. Instead of bad character, Brian Albert was a two-time recipient of the George Hanner Award, has many, many medals of honor from the Boston Police Department.
You know what's so funny about this case? He won awards, and you know what else happened in this case? Everybody involved in this investigation, this piss poor investigation, got promoted. Remember Sergeant Lank, who has been inserting himself in the Albert business for decades? And the Commonwealth paid $300,000, not the Commonwealth, but the town of Canton, I think, paid $300,000 to the Lapalato brothers for the civil rights that were violated by Michael Lank in defense of Chris Albert, go figure. And as part of that settlement by the town of Canton was that Michael Lank was not supposed to receive a promotion. I found that out because I watched the town of Canton board meeting the other day and somebody brought it up. But guess how many promotions Michael Lank has received since that settlement? A few. Everybody got awards. Everybody got promoted because this is what they've been doing for decades.
The issue. They suggest that he was involved. So they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe. And other than being at the bar that night and Mr. O'Keefe and Miss Reed pulling in front of his property that night, there is no association between the two. They say he's present at the scene of death. By all evidence, Mr. O'Keefe died feet from the street near the flagpole in front of 34 Fairview. So that's a little bit broad. He wasn't present at the scene of the death.
Well, see, the scene of the death was inside the house, and you know what had happened was, first of all, tell him the guy never went in the house, and second of all, no law enforcement ever searched the house or looked in the house. So there's that. Wonder if anybody remembers when they were in the foyer, Lank, because Lank was the friendly that they were waiting for. He's the only guy they let in, him and I think Sergeant Good, maybe. I don't know who was with Lank, but do they remember the dog coming down or hearing the dog barking at all? I wish somebody would be asked that question, because we think that the dog was probably removed from the scene that evening.
He wasn't there. That happened out front on the front yard near the flagpole, about 70 feet from his house. The body was found feet from his front door, arguably, 70 feet, 75 feet. He admits to being home. He doesn't have to admit. He was home. Now, here is another claim without any evidence whatsoever. The defense states emphatically, computer forensic data overwhelmingly establishes O'Keefe entered Albert's house.
Yeah.
I haven't seen that evidence. Based on what? So if they're going to make an offer of proof to the court and they're going to make claims to substantiate this theory, they have to have proof of it. And in their motion, I see no proof whatsoever that overwhelmingly establishes John O'Keefe went into the Albert house. In fact, what we see is the opposite.
It doesn't need to
In the
be
past trial.
overwhelming. It just needs to create reasonable doubt. See, here's where you're kind of mixing up the whole burden of proof thing and reasonable doubt thing. They've got 12 experts coming in, assuming the judge is going to allow them. Several of them are forensic experts that are going to be able to pinpoint his location in even greater detail, because they were able to do that in the Brian Walsh case. And the Brian Walsh case, some days he went to his mother's apartment building. One day he went to the dumpster at the apartment building, and they could tell based on the location data. So buckle up, Hank. It's going to be a bumpy ride.
Numerous people were called. Every single person that was asked stated they did not see John O'Keefe enter that home.
And the
Every
guy
single
never
person. Now, whether you believe it or not is irrelevant. What's relevant is there's nothing to the opposite. There's an absence of evidence to the opposite. In fact, the phone data and the way.
Yeah, whether the jury believes it or not, though, creates reasonable doubt. Is he talking to the judge, whether you believe it or not? Who's he talking to? The media?
Data in the GPS and all the data puts John O'Keefe at the front yard, not in the house. So if they're asking the court to make a finding of substantial link and substantial proof that John O'Keefe was in the house, they have to actually give you the facts and the science and the data to support that. And I don't expect that will happen.
Give it to you, judge, or give it to the jury, Hank?
They add that there was going to be expert testimony that the scratch on John O'Keefe's arm was from an animal or a large dog, and because Brian Albert had a dog in the house, there was some type of inference.
The scratch to John O'Keefe's arm. Does anybody want to dissect that sentence and point out what's wrong? The scratch on John O'Keefe's arm.
Dr. Russell has already testified at the Lanigan hearing that she's not saying that those bite marks were from Chloe. Although it has not been decided by the court, Dr. Crosby has done molds that show that the teeth comparison is totally an opposite. And so even the defense is not saying, as I see from the disclosures, that Chloe bit John O'Keefe. Their version, which we don't agree with, is that a large animal or a dog caused these wounds. They don't say where, they don't say when, they don't say how. And so that is not a link so that Brian Albert becomes a third-party culprit. Finally, in a way to try to create some type of traction against Brian Albert, they associate him with Brian Higgins because they spent the day together, because Brian Higgins, according to them, was rebuffed because of phone calls at night.
He was ghosted.
All of these general claims with no fact predicate rely on innuendo, surmise, speculation, or just the creation of an inference that does not exist. There is no evidence Brian Albert had any motive whatsoever to harm John O'Keefe. None. There is not one witness, there's not one statement that Brian Albert had any animus whatsoever towards John O'Keefe. None. He did not have the motive. He did not have the opportunity. And there is no evidence that he was involved in any way in the alleged collision that happened in the front of his yard that night.
The alleged collision, at least he said alleged collision.
Finally, the defense turned to Mr. Higgins. Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information, and I would suggest don't tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed had kissed Mr. Higgins at John's house. That seems to be corroborated in the text messages. According to the text messages, Mr. Higgins said,
Hold on, Elmer Fudd. It's corroborated. Hold on, I gotta hear that again for the comic effect. Hold on. Corroborated.
Mr. Higgins at John's house. That seems to be corroborated in the text messages. According to the text messages, Mr. Higgins essentially says that Miss Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Miss Reed went to Mr. Higgins' house. And so there was some interest, it would appear, from the text messages between the two. Mutual, at best. There's a plethora of text messages where Miss Reed is pursuing Mr. Higgins, looking for his time, looking for his attention. In one, she says, of basically begging him to come over. Do you like me? Come over to my house. There are text messages talking about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them. What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe. The fact that they are texting together and later that night he sends a text message because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship, is not evidence of motive. In all of these text messages, you never see any animosity towards John O'Keefe.
You know what else you don't see? What you do see is a man who wants a future with Karen Reed because he wants to know where this is going. He wants to know where it's going. He wants her to define the relationship. You know what else you don't see? You don't see Brian Higgins reaching back out to Karen Reed after the death of John O'Keefe, do you? She texted him that morning, January 29th, John's dead, and he ghosted her. What does that say to you? He could have white knighted her. He could have been like, how can I help? Oh, come to her rescue. He wanted a future with her. He's a beta. And he didn't reach out. He didn't reach back. He didn't try and comfort her. Very strange.
Mr. Higgins's text messages are virtually all kind towards John O'Keefe. It's uncomfortable. It's an awkward situation because both of them appear to be deceptive as it relates to John O'Keefe. But there is no vengeance. There is no anger.
He didn't text John except to say, you coming here? You coming here? And again, the other time after the Super Bowl party where he broke his nephew's PlayStation controller or something, and he was embarrassed about how drunk he was. You coming here?
Suggestion that there is a motive because there was flirtatious text messages to then kill the man is beyond the pale. It's beyond any logical connection that would support third-party culprit. Brian Higgins sent a text message saying to John O'Keefe, asking if he was coming to the home that night, and they then attached the word he lured them to the house. I mean, we do look at this evidence not in a vacuum, but logically and realistically. Not knowing that Karen Reed was not going to come in when they arrived at the house. Is it reasonable? Is it rational? Is it lucid to think?
Is it rationable? Is it rationable? Can we create rations for when we are stranded on a desert island as a soccer team in Yellow Jackets? Can we make it rationable? Can we make the body meat last a long time? Is it rationable? I'm sorry, really? Dude, the more I look at him, the more he does look like that weasel on the thumbnail, and it's kind of funny. Yeah, is it rationable? Yes, it is. He was trying to steal John's girl, dude. Let's hear that again for comic effect. It was corroborated by the rationable assumption that he wanted John's girl. There's no bro code.
Realistically, not knowing that Karen Reed was not going to come in when they arrived at the house, is it reasonable? Is it rational? Is it lucid to think that that Mr. Higgins was inviting them both over to the house, not knowing only one of them would get out of the car? Is the suggestion that Mr. Higgins was going to kill both of them? Or he was.
They saw her drive away. They saw her drive away. Remember the curtain twitchers? Jen and Matt McCabe watching her car? and they saw her drive away. So they knew she wasn't coming in the house. And drunk people do not need a reason to fight. These guys were drinking for days.
He was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways. The absurdity of the relationship between the claim and reality is so great that it will just run rampant through this trial. It would be unrelated, speculative, shotgun approach to claims that the witness will spend their time trying to explain and defend. It will distract the jury, and it will serve the purpose, which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from. And that attempt to divert anybody but the defendant is the attempt here. That's why
Really, she shouldn't be able
we
to.
don't know who, but
She should not be able to present a defense at all because we just want to convict her, Judge. She should not be able to introduce any evidence that anybody else could have been responsible for this because that distracts from the case at hand in which we want to convict her of motor vehicle homicide, facing a life imprisonment sentence, murder in the second degree. And she should not be allowed to introduce any evidence because it's distracting from our conviction. Listen to that again.
for the case we're here from. Serve the purpose, defend, it will distract the jury, and it will serve the purpose, which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from. And that attempt to divert anybody but the defendant is the attempt here. That's why we have three, we don't know who, but three potential third-party culprit evidences with absolutely fragile evidence. It's feeble. They, as their support, what they offer is.
All right, you're gonna have to take a drink every time he says feeble. That's like the fourth time. A distractor, look the other way. I just look at Kelly Reed's face. I think she speaks for all of us. Just a distractor. Don't distract us from our conviction, Judge. Don't allow it.
They believe Mr. Higgins lied because he went to the Canton Police Department to do administrative work. And I think the evidence is clear that he had cars that he parked there as part of his job that he needed to clean off. So they are parsing words in an attempt to create a basis that doesn't exist.
Why'd you hide the video of him on the phone outside the Sally Port? Why'd you hide the video until like last week? He already screwed himself on his testimony. Notice how he's not trying real hard to defend Higgins, just the Alberts. Notice? I did.
That there are calls between Mr. Albert and Mr. Higgins later that night. So what?
So
They
what?
have no evidence that either of them spoke to each other. They have no evidence of conversations. They have no evidence of a conspiracy. They have no evidence of a
22 seconds is evidence of a conversation. Butt dials don't last 22 seconds. And if you think Brian Albert and Nicole Albert were doing the nasty and that's how that butt dial happened, give us a break. 2:22 in the morning, 5 minutes before Jennifer McCabe's phone Google searches Haas long to die in cold.
cover up. They have no evidence of a weapon. What we know is John
Fists.
Keith never went in the home. And so to try to create this image based on obscure facts is not the substance that's required under third-party culprit. I know third-party culprit is a time-honored tradition and is a broad latitude,
Yes.
but it's not endless. It can't prejudice the Commonwealth. It can't distract the jury. It can't be.
It can't
based
prejudice the
on
Commonwealth.
fiction. It has to be based.
It can't prejudice the Commonwealth. It's a time-honored tradition, just like he said it was a time-honored tradition for the third-party culprits to be allowed into closing arguments to stare down the jury. Wow. He said create. Hold on, we got to hear it again then.
But it's not endless. It can't prejudice the Commonwealth. It can't distract the jury. It can't be based on fiction. It has to be based on an identifiable theory. The cases that have allowed third-party culprit that have been reported have actual people who could be a third-party culprit.
We have
who
better
actually
people
have
here.
relationships to the scene of the crime or the deceased.
They were all at the house.
In this case,
They were all at the house. Nobody saw a body on the lawn. They all drove past the lawn at least twice to get there. Dude, what planet are you from? Kat says he's from Uranus. I wonder if like certain people who may be sitting in the courtroom, like every time the sirens go by the courthouse, if their butt cheeks clench. I'm just wondering.
attempt to call Mr. Higgins a liar or create fictions about what they think he could have been doing or guessing what they want him to do is not evidence. 9 people testified John never came into the house. 9 people. There is no overwhelming evidence or any evidence he went into the house. There is no evidence of motive on any of these 3 people they identified. They've had, before the last trial, the entire trial, and was aptly pointed out, no request for a third-party culprit instruction. And then they had since then to make an actual proffer that people actually have the motive, opportunity, and intent to do this. That there's actual evidence that there's this alternative theory, and they failed to do it.
It's up to the jury to assess the credibility of these 3 witnesses to determine whether or not the jury thinks that they are lying. See, that's what a jury trial is. The jury is the finder of fact, and the jury will decide whether those 3 people are lying or hiding something or show consciousness of guilt in the hours after the murder and the days thereafter, all the way up until today.
Defense go through a trial, distract the jury.
Distract the jury.
Attack the reputation and character of the witnesses, and then not even ask for an instruction at the end. It evidenced the fact that there is no basis for a third-party culprit. Now, separately, third-party culprit is part of Bowden. Even if the defense at the end does not warrant an instruction, I recognize that challenging the police investigation is virtually an entitlement of a defense. How they do it and the extent they can do it is a different story. Simply because they have an attack on the police investigation does not let them use third parties as part of that. And so the standard, Silva Santiago, is very clear, it's cited by almost every case, is that there has to be something the police didn't do at the time that they knew about and should have done.
Body was found on the lawn.
At the time the police did their investigation as being criticized, they would have had to have known about a potential third-party culprit or third-party culprit evidence and didn't pursue it. And that's what the defense argument.
Right, because Michael Proctor decided within 16 hours that he was going to pin it on the girl. The Boston homeowner was not going to catch any shit because he's a Boston cop too. And, all good. 16 hours. They never investigated anybody else. They lied about Brian Colin Albert being there. They misspelled witnesses' names on the police reports. And nobody ever searched the house. They didn't go in the house. Nobody secured the scene. Like, I'm embarrassed. I have third-party embarrassment now. This is why people hate lawyers. This is why. He's the poster child for people hating lawyers.
Utterly fails here. Because at the time the police were doing this investigation, what they knew is that John O'Keefe was on the front lawn of 34 Fairview near the street. They knew that he was dying or is dead. And a number of witnesses knew.
Ooh, remember his theory that Karen Reed hit him and she left him there, and he's got that neurosurgeon who's going to come in and say that his life could have been saved if she stopped and called 911. And did you notice he just slipped and said he was dying? And then he was like, or he was dead. How about the witnesses who said, like Paul O'Keefe, who said it looked like he just went 5 rounds with Mike Tyson? How about that? How about Yuri Buchanan calling it in as a domestic assault? How about Chip or Bear or Proctor in the text message thread with his buddies talking about, somebody asked him, oh, so you think the girl beat him up? Come on. There was so much evidence of a fight that it's embarrassing that you're making this argument. How about your own medical examiner cannot say that this was caused by a motor vehicle? But she does say in her autopsy report, this does not seem to be consistent with a fight. You know what else it's not consistent with? Dying in a fire, drowning, jumping off a building. But she specifically puts in there, the injuries do not seem to be consistent with the fight. Come on, man. Come on. The world is watching. The world is watching. We can see it.
That Miss Reed was saying, I hit him, I hit him, I hit him.
Never in any report does it say that.
A number of witnesses.
No, never
Shortly
said.
thereafter, what the police knew is that Miss Reed's taillight was cracked. And shortly after, what they learned and knew after they got her car is that part of her taillight was missing.
You know what's funny about that? They never took a
So
picture.
at that time, when
They never took a picture. Never took a picture of that car in her parents' driveway. Nope, they didn't. The only pictures they have were from after they removed the tail light. Funny the way it is, if you think about it. He had a camera in his pocket, but what? It was too snowy for him to take a picture. He didn't want to stand outside in the cold and take a picture. We're not buying what you're selling.
they were doing their investigation, there was no claim of dog bites. That came months and months later. They went to 34 Fairview and they spoke to the owner, according to the witness testimony. And everything seemed appropriate. Concerned, confused, no blood, no scratches, no cover up, no turned over furniture.
Lank was also sued for his defense of the Alberts with the Lopalato brothers, paid $300 grand. Again, Lank was the friendly. Yeah, everything seemed just fine. Did it smell like bleach? Because, you know, Coco loves to clean. She was cleaning all night. Did it smell like bleach? Was the dog there? Did Julie Albert bring donuts?
There was nothing that would have alerted the police officers that there was any road to follow other than the road they followed. Now they can be criticized for plastic cups or leaf blowers, but that's different. That's different. In order to have third-party culprit under Bowden, the police would have to have known that there was information that targeted or pointed out a different person, and they didn't pursue it. So in the cases cited by both the Commonwealth and the defense, there are a number of cases that talk about information that was known to police at the time they were investigating and they failed to pursue it. That is not this case. That is not this case. There is nothing in any of these proffers that show actual evidence that the police knew of these later third-party culprit claims by the defense, or they knew at the time they're doing this investigation that there was any other lead. And likely the reason was is because there wasn't. The evidence for a reasonable police officer pointed towards the statements, towards the car, towards the light, and that was followed up, which led to DNA in hair and all the other evidence that followed, the data.
Mm-hmm.
And so as a concession to the defense, they don't simply get to bring in third-party culprit through Bowden because they failed in the instant case to show a third-party culprit. That's not part of their entitlement. And mindful that if they do raise Bowden, whether they get instruction or not, it is broad. And that means the police, including any police they would call in this case, or we would call, is entitled then to share their state of mind, why they did not do something. That can open doors to inadmissible evidence, privileged materials. The state of mind of the officer is relevant if they make it relevant. So we should not engage in a process where we allow witnesses to be asked questions with no ability of the defense to follow up those questions with actual proof. We should not engage in a process where witnesses, their character is attacked when it has no relationship whatsoever to this crime. And witnesses shouldn't be put through the ordeal of defending themselves based on generalizations about supposedly being violent or having a temper. There needs to be that nexus, and it fails. It is beyond feeble. And so I ask Your Honor not to allow third-party culprit in the incident, and you should not allow it as part of Bowden.
There was no legal argument there, and it was corroborated
Yes.
and rationable. Oh, Yannetti.
Your Honor, the Commonwealth's motion raises.
Okay, before we listen to the king, let me just point out that the queen is also here. Queen Tanis Yannetti is here. She's David Yannetti's sister. She's also a new cupcake. Queen Tanis, love you so much. And happy birthday to Jen D. And when there's no place else we'd rather be than with you. And here's the king. And take it back so we can hear him from the beginning, because he deserves it.
Your Honor, the Commonwealth's motion raises three interconnected issues, not just two. I believe that two of those were conflated by the Commonwealth. I'd like to separate them out. The first issue is the introduction or admissibility of evidence relevant to show that somebody else harmed John O'Keefe. The second issue, which I think was conflated with the first, is whether after the introduction of such evidence, the defense is allowed to argue that a specific person or persons caused John O'Keefe's death. And then the third issue is whether the police properly investigated this matter in light of the information that they had or information they could have obtained or failed to follow up on to show that somebody else caused John O'Keefe's death. Regarding the first issue, which Mr. Brennan spent a lot of his argument on, there is ample evidence tending to show that somebody else caused John O'Keefe's death. In our opposition, we have cataloged the evidence against each of the potential third-party culprits that we named the last time we were in court. Each one of them had a motive and an opportunity to harm John O'Keefe. The investigators in this case had evidence that pointed to Brian Albert. Brian Albert is a violent man. He was not only a boxer who punched people in the ring, he was also a violent drunk who sucker punched other police officers. Those police officers are on our witness list. He's been investigated by the.
What? What just happened to their feed? Stop it. Stop it. Don't even tell me. Nope. We can't allow that.
It exists. At the time, evidence, but it exists.
Here's where we left off. Brian Albert is a violent drunk. He's been investigated by Internal Affairs for it. We have two people that are going to come in that he's punched in the past. He's a violent drunk. Say it like it is. King David, say it like it is.
With that interpretation of the evidence, but it exists. It's a live issue at trial. At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up. He testified to that. He was at the hillside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard where Mr. Brennan claims that he was at the relevant time period. That day and night, Brian Albert was attached at the hip to his close friend, Brian Higgins. This was the night that after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night. Higgins had expressed his interest, but it went nowhere. And it went nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him. She stopped returning his messages. Brian Higgins was liquored up that night as well. They're both very large men. The court saw them on the video. Friends who drank the entire day and night, and they were waiting in the house for Mr. O'Keefe to arrive. Mr. O'Keefe ended up dead because he went to Brian Albert's house. After Brian Higgins left, Brian Albert maintained contact with him. At 2:22 in the morning, the two of them were exchanging phone calls to check in with each other just a couple of hours after Mr. O'Keefe was mortally attacked. Mr. O'Keefe had dog bites and or scratches on his arm consistent with a dog or an animal attack. Brian Albert had a large German Shepherd who had attacked and injured somebody in the past. It all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect. And I'm sure the court remembers the words in a text message of now ex-trooper Michael Proctor, the lead investigator who's now been fired as a result, in part, of being biased in this investigation. I would point out also that when Mr. O'Keefe was in the house, both Brian Albert and Brian Higgins were unaccounted for, according to the testimony. With regard to Michael Proctor's words, he was asked specifically if the homeowner would catch any grief for having a deceased person on his front yard, and Michael.
All right. I heard some people saying that NBC 10 does not cut out, so let's see if we can go there, because I don't know how many times it's going to happen. So, you know, we might as well just go back. But if it's only like moderate, like if it's not too long, I've already modulated the volume, so I just want to see how long this is. All right, it's not very long, so I think we just need to stay here for now, unless it goes out again.
Responded. It's worth stressing that Brian Albert was a first responder. He chose to ignore his duty to help somebody in need and instead stayed in his bedroom. And Brian Albert's dog, the family dog, a member of the family for 7 years, Brian Albert got rid of the dog, shipped it to another state, only after it was made known in court that the defense was alleging that the dog had been involved in the attack on John O'Keefe. We showed photos of John O'Keefe's arm in a public hearing where it was clear to any unbiased observer that Mr. O'Keefe suffered those particular wounds from a dog or animal attack. Brian Albert responds to that allegation by essentially divorcing his family from their beloved dog, whom they had had for 7 years and certainly considered to be a member of the family. In the aftermath of John O'Keefe's death, Brian Albert went so far as to send that family member to another state. That's enough evidence to point to Brian Albert as a potential third-party culprit in this case.
All right, the problem is that Boston 10 is way behind. They still have Hank talking. So they may come into this problem when they get to Yannetti
Ms.
talking.
Reed was the one and Ms. Reed was the one to end the contact. She stopped responding to him. She no longer gave him any attention. So we come to January 28th. Brian Higgins sees Ms. Reed in person, but she's not alone. She's instead with Mr. O'Keefe. Ms. Reed and Mr. O'Keefe are affectionate with each other that night, and Higgins is there to see it, as is Brian Albert. There's evidence that Mr. Higgins wants Mr. O'Keefe to come to the Albert's house that night. In fact, he appears fixated on making sure that Mr. O'Keefe went there. In the waterfall video, Your Honor, you will see that Higgins motions to Mr. O'Keefe when they're leaving. And Higgins even texts him directly after that to make sure that he was coming. Then Higgins goes to the Albert home. John O'Keefe goes inside. Higgins is there waiting for him, with both the motive and now the opportunity to hurt John O'Keefe. Like Brian Albert, there's evidence of his consciousness.
They don't want you guys to hear this. They do not want the world to hear this. This is like, is somebody outside jamming the signal?
But he's also going there to move a vehicle, but he's always maintained, including in the first trial, that he never called anyone. We've learned since that trial that Higgins is at the station on video making a phone call. So I suppose the question is, why did he lie about that? The jury in this trial should be entitled to consider the answer to that question. And of course, the police never investigated who he was calling or what he said or who was calling him. Then he goes home and he still stays up And at 2:22 in the morning, he's speaking by phone with Brian Albert. And he
And they-
claims that they didn't, but
And they hid the video of him talking on the phone. They had the video and they hid it from the defense.
phone records don't lie. And this notion that these two men are somehow able to butt dial and butt answer each other is just ridiculous. And there's more consciousness of guilt evidence with regard to Higgins. When he realizes that investigators might be interested in the contents of his phone to see what evidence might be on it, he demonstrates consciousness of guilt by getting rid of his SIM card and the phone itself. And how he got rid of it was extraordinary and demonstrates just how badly he wanted to keep that information out of the hands of investigators. He admitted to breaking the SIM card into and making a special trip to a military base to put this tiny object, the size of about a thumbnail, into a large dumpster. It wasn't enough to throw it in a waste paper basket or a trash bin outside the local Dunkin' Donuts. Instead, he went through security at a military base and secretly tossed this tiny broken SIM card into a dumpster. He made sure that investigators would never know what's on his phone, and he admitted to that at the first trial. And of course, the investigators in this case, including the lead investigator, former trooper Michael Proctor, never showed any interest in Higgins' phone. Higgins nonetheless accomplished his goal of keeping the contents of the phone out of the hands of the defense in this case. That's powerful evidence of motive, intent, opportunity, and consciousness of guilt of Brian Higgins. As Mr. Brennan acknowledges, all doubt should be resolved in favor of the admission of third-party culprit evidence, linking him to the harm caused to John O'Keefe. And finally, Colin Albert is a potential suspect. He had been in a feud with John O'Keefe. He'd thrown beer cans in his bushes, told him to F off. We have a good faith basis to claim that. This is the same Colin Albert who testified under oath he had never been in a fight in his life, yet there are videos of him clearly desperate to beat up others. The same Colin Albert who had scraped up knuckles just a few weeks after John O'Keefe's death. Those knuckles looked consistent with an attack on somebody. The photographs that Mr. Brennan references that were allegedly before that photo had no metadata. We can't confirm when those were taken. Mr. Brennan wants us to just accept the testimony that they were taken before the scraped up knuckles photo.
Right.
We don't buy it. We don't think the jury will buy it. When John O'Keefe was found, he had two black eyes looking like he had been punched in the face. Colin Albert was at his uncle's house with both his uncle and Brian Higgins, disliking Mr. O'Keefe for a different reason, but disliking him nonetheless. And it's suspicious that Colin Albert's name was purposefully omitted out of the police reports. There was no indication in any police report provided to the defense in the first few months of this investigation that Colin Albert was anywhere close to 34 Fairview, his uncle's house, on January 29th. In fact, there's no indication in those police reports that Colin Albert even existed. Initially, we didn't even know who he was. But we found out when we sent a letter to Mr. Lally, while the case was still pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness before the grand jury. It was only after we sent that letter notifying the prosecution that we were onto Colin Albert that testimony was elicited that Colin Albert was indeed at 34 Fairview that night.
Right.
The defense caused this to be revealed, not any investigator of this case.
That's right.
There's obviously an inference that his name was kept out of the police reports to protect him. The same way Brian Albert is the only person listed in the initial report whose first name is not even spelled out. He's just listed as B. Albert with an incorrect address.
Yeah.
There appeared to be a conscious effort of these investigators to hide third-party culprits from the defense. All of these men, Brian Albert, Brian Higgins, Colin Albert, were present at 34 Fairview the night that John O'Keefe was killed, and each had a motive, intent, and opportunity to cause him harm. Now, there are many cases, Your Honor, I know the court is aware of this, endorsing the admission of third-party culprit evidence. Almost all of them allowed in a third-party culprit defense, despite a lack of evidence that the third-party culprit in those cases was actually at the scene of the crime at the relevant time. The first case cited by the prosecution, Compel versus Conkey, Middlesex County case, I remember it from the 90s. It was retried in the early 2000s. In that case, a person was murdered inside a home, just like this case. Unlike this case, however, the defense could not place the third-party culprit at the home when the murder was committed. He lived down the street, and that was enough. Here we have hard evidence, irrefutable evidence, that the three potential third-party culprits were present exactly when the murder was committed. And it's notable that the defense in Conkey, in that second retrial, after the first trial conviction was reversed, the defense was allowed by the trial judge to present a third-party culprit defense, and it wasn't controversial. But the conviction was nonetheless overturned, the second conviction, on appeal, because the trial judge didn't let the defense go far enough in presenting that defense. The SJC ruled that in addition to presenting evidence of motive, intent, and opportunity, the defense in that case should have been allowed to introduce past sexual assaults of the third-party culprit, including one that took place 7 years before the murder. It was reversible error not to permit a full third-party culprit defense, including prior bad acts of the third-party culprit. And I will ask the court to consider Commonwealth versus Finney, a case that I'm...
Before he talks about Finney, that was his case. Notice how did Hank Brennan talk about any case law during his argument / statement to the media? I don't think so.
Very well familiar, as I previously mentioned. I brought that motion for new trial. I argued before the Supreme Judicial Court, and I tried the retrial of that case, so I know it well. The SJC affirmed Judge Ball's allowance of the motion for new trial in that case, ruling that it was ineffective assistance of counsel that the attorney did not raise a third-party culprit defense. The case law makes clear, as Mr. Brennan again acknowledges, that this defense is a time-honored method of defending against a criminal charge. The defense should be given wide latitude to present relevant evidence that somebody else committed the crime. But the main issue in Finney was whether the defense could introduce hearsay to support an already admissible third-party culprit defense. It's sort of like Conkey, where it's just assumed, yes, of course you can present a third-party culprit defense. But in Conkey, can you introduce unrelated sexual assaults from 7 years before? The answer was yes. And in Finney, of course you can present a third-party culprit defense. But can you also introduce hearsay to support that defense? It was a given. In fact, it was reversible error that the third-party culprit defense was not brought the first time around. Mr. Brennan talks about, well, you can't do this if it prejudices the Commonwealth. That's crazy. Yeah. Every single time you introduce a third-party culprit defense, you are prejudicing the Commonwealth by definition. You're not going along with their theory of the case. Mr. Brennan's aggrieved that we would deign to present this defense. And I would note, Judge, there's I believe a certain amount of gaslighting going on here, in that on one side of his mouth, he talks about he wants Ms. Reed to have a fair trial. But we've spent weeks where he's just trying to knock out all our evidence, just limit everything. He's, I believe, acting more like a defense attorney than a prosecutor in that regard. But regardless, in terms of these cases, Mr. Brennan said that they all have third-party culprits who have relationships to the alleged victim and/or relationships to the scene of the crime. Finney did not. In Finney, my client was the next-door neighbor. My client signed a confession to the murder. The third-party culprit lived several houses away within the same city, but not close, not next door. There was no relationship other than he made statements about how the victim probably deserved what she got and she wasn't the goody two-shoes, but there was no, that she was made up to be, but there was no witness that put the two of them together in any way other than those hearsay statements. Nobody put him at the scene of the crime. The SJC ruled even hearsay should be admissible to support that third-party culprit defense. The defense in this case has more evidence of third-party culprits than the defense did in Finney. We're not asking this court to allow into evidence hearsay, as was admissible in Finney. We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Brian Albert, Brian Higgins, and Colin Albert had. That's the nuts and bolts of a third-party culprit defense. So that's the first issue, presenting evidence of a third-party culprit defense. The second issue is whether we can argue in closing that a third-party culprit is responsible for John O'Keefe's death. That's an issue I suggest that the court does not need to decide now in advance of trial. Closing arguments come at the very end of trial. At the charge conference, this court would be in a position and would be entitled to evaluate the evidence as it came in and to make a decision at that time prior to closing arguments as to what we can argue and what we can't. And while we believe the court has enough evidence now as a result of the first trial and as a result of our proffer and our submissions and oral argument today to rule that a third-party culprit defense is permissible, but this court at a minimum should not deny argument on that issue before evaluating the evidence as it comes in. And that brings us to the final third issue, a Bowden defense. Obviously, attacking the inadequacies of a police investigation is bedrock constitutional law. It's a bedrock constitutional right. In this regard, in one sense, the discussion about the third-party culprit evidence is somewhat academic as opposed to a practical one, because all of the evidence that points to Brian Albert, Brian Higgins, and or Colin Albert, all of it comes in to show the lack of investigation, the lack of curiosity that the police had, and the lack of investigation that they did to rule any of them out. And it comes in to show the bias of the investigators of this case. Bias is also a constitutional right. They were perfectly willing to jump to conclusions about Ms. Reed, someone outside their law enforcement circle, on the wrong side of the blue wall, but very much unwilling to be curious about whether someone within their circle had the motive, opportunity, and means to hurt John O'Keefe. Former Trooper Proctor specifically told his friends he had no interest in investigating someone connecting with law enforcement. And in their internal affairs findings, his superiors noted that his apparent bias was one of the reasons he was fired. You have a stronger Bowden defense than that. So
we know that because we read the internal affairs report. That was Proctor he was talking about.
I would argue, Judge, that the Commonwealth's motion really comes down to what the defense will be able to argue in this case. Our position is we should be able to point the finger of guilt at those who might have done this, but at a minimum, given that the evidence will be coming into trial anyway on the Bowden issue, the court should reserve judgment on what we would be allowed to argue from now, weeks from now, when closing arguments are upon us. This evidence, in conclusion, in our view, must come in. This is a due process constitutional right of my client, and it has to be admitted for two reasons. Number one, it's a time-honored method of defending against a criminal charge by pointing out that somebody else could have done this. And number two, it's a time-honored method of defending against the criminal charge by pointing out that police investigators failed to do their jobs correctly. We have a stronger third-party culprit evidence situation here than existed in either Conkey or Finney. And we assert it would be reversible error for this court to exclude this evidence. Unless the court has further questions, I would rest on my mind.
Karen Reed was on the wrong side of the blue wall. That's the quote that stuck with me the most. She was on the wrong side of the blue wall.
I'm going to choose to focus on case law
Oh, really now?
and the facts that aren't presented by the defense.
I think that's the
You
intern
see in
that
their
just walked in.
motion,
I'm not
there's a
sure.
grand claim that there's extraordinary evidence that John O'Keefe went into 34 Fairview that night. That is critical because there is no basis to accuse somebody of murdering another person if they don't have the opportunity. In other cases, a third-party culprit is not necessarily found at the scene, even in Finney. It's more than just a couple of derogatory words in Finney, as counsel knows. There was a neighbor who had an axe or a club. He was seen with blood, went home, washed his clothes, wholly irregular. And because of this irregularity and the timing, he was then asked by his then wife about the victim, and he made a number of derogatory comments about her.
Okay, how
showing
come,
ill will.
how many derogatory things did Michael Proctor say about Karen Reed? How come she didn't say to him, don't tell me what you're going to do, Mr. Brennan, just tell me. Remember how she like shamed Alessi the other day in open court? It was revolting and was laughing like, I thought maybe you're going to tell me like what you were going to tell me. And then you were going to tell me what you were going to tell me. And then you were going to tell me what you already told me. You're not going to do that, right? Motion to speed him up a little bit. Granted.
Evidencing tangentially motive. And so no, a third party does not necessarily have to be at the scene at the time the police investigate, but they have to be with the deceased if they caused the death. It's obvious. And so we didn't hear any extraordinary evidence, none. We didn't hear kind of good evidence. We didn't hear any evidence.
They were
We
all at
just
the
have the
scene.
bald assertion that
They
the
were all
data forensic evidence will show that he was in the house. It didn't. It doesn't. They don't have a proffer. So there is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision.
You can show third-party culprit.
The
He's insane. His argument doesn't even make any sense. Every single person that's named in third-party culprit was at the location. There's evidence of that.
defense's effort to tell a story. Take a couple of facts. Someone's a boxer, they drank alcohol, and convert it into a story is how they will try to portray these unsubstantiated facts at trial. They'll tell a story. It will divert the jury's attention. So they're not entitled to it. They're not entitled to it. Time-honored tradition, yes, but there are limitations. Silva Santiago was very clear about the limitations. This latitude is not unbounded. Each of these limitations recognizes the admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth. I'm not whining. The Commonwealth should not be unfairly prejudiced. The people of the Commonwealth should not be unfairly prejudiced because it is inevitably, it diverts jurors' attention away from the defendant on trial and onto the third party. Essentially, it requires the Commonwealth to prove beyond a reasonable doubt the third-party culprit did not commit the crime. If there was evidence of third-party culprit, the defendant should be entitled to use it. In this case, there is not. There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. Certainly the defense can infer certain facts like getting rid of the SIM card in a way they want, and I don't begrudge that at all. There's different interpretations of it. I understand that. This was heavily considered in the federal investigation. And after that absolute thorough investigation, there were no charges. There was no evidence of third-party culprit. There were no indictments.
Okay, hold on. He's going to talk about the federal investigation as part of his argument. Hang on. Didn't see that in his papers. Did he put those in his papers? Hold on a second. Indictments could still be forthcoming. They could reopen that investigation at any time. And we really do not have any evidence that it was actually really closed, except from Canton Police Chief Helena Rafferty, who wrote on her letterhead that she says it's closed, but she's not with FBI.
Certainly the defense can infer certain facts like getting rid of the SIM card in a way they want, and I don't begrudge that at all. There's different interpretations of it. I understand that. This was heavily considered in the federal investigation, and after that absolute thorough investigation.
How do you know that was heavily considered in the federal investigation? You've been telling us that your TUI requests are being ignored and it's a long, dark, deep hallway and you never get anything from them. But now you're saying it was thoroughly considered in the federal investigation? Because I don't know how he can make that statement in open court.
There were no charges.
Yet.
There was no evidence of third-party culprit. There were no indictments. And so,
'Cause there was no
although we don't know the
investigation.
parameters of the federal investigation, and we can only guess as to some of it, we know from what we did receive in review, it was thorough. And if there was third-party culprit evidence, we would expect that there would be a basis for it. It's not an entitlement to simply bring it in under Bowden. I don't defend that there was commentary in the officer's phone that was inappropriate.
Do you notice how he keeps talking about Karen's entitlement? She doesn't have the entitlement to bring it into the third party coverage. She doesn't have the entitlement to point the finger at anybody else. Like, she's so entitled. How dare she defend herself? It's revolting.
Automatically create a situation where there is evidence that the police officers knew that there was somebody that should have been investigated. In fact, when Mr. Albert came down the stairs, the testimony is the police officer was already inside his home. There's no evidence Mr. O'Keefe, a first responder, was still outside, that aid could have been rendered.
He was a friendly.
It's not speculative. It's just piecing together different facts and telling a story. So inevitably, while I recognize the case law, there are plenty of cases that talk about third-party culprit should not be admitted if inappropriate. Commonwealth versus Stedman. In that case, a person, not the defendant, was in a fight with a person at a campsite. And then later, the defendant supposedly went back to the campsite, a friend of this person, Royal, and used a knife to stab and kill him. And the defense wanted to introduce prior convictions about the fact that this supposed third-party culprit had attacked people at other homeless sites. Pretty close relationship. A person having a history of attacking people at homeless tent sites. And the court, looking at 403, did not allow it as third-party culprit. They said that the admission would be feeble, pose a risk of unfair prejudice. In that case, there was third-party culprit admitted pursuant to Bowden in a very different way. Commonwealth versus Moore. The court would not admit layered hearsay showing different identifications that were relayed by the police from third parties regarding a culprit. They said that the hearsay was uncertain, the source is unreliable, and it was inadmissible as third-party culprit. So it is not an entitlement to be third-party culprit. Commonwealth versus Buckman, 461 Mass. 2011. The defendant was charged with murdering his wife. When they received a report from one of the defendant's friends, the defendant was softly tied to a pole that looked like he had been kidnapped. Inevitably, the police determined that he had help or tied himself as a ruse. And this person, the helper, his friend, had connections to gambling, was there, and when the police couldn't find the body, he knew exactly where the body was. That case is far stronger than many. And in that case, no motive, no intent, and they did not let a third-party culprit defense go forward. Facts suggesting that one side believes a person's telling the truth or not is not facts of third-party culprit. It's just not here in this case. And again, I iterate my position on denying the defense to cross-examine witnesses about these generalizations and these character attacks. I think it will mislead the jury, and it will become a total diversion for the jury. And I don't think the basis is anywhere close. It's feeble.
It's feeble. How many times did you say feeble? Oh, thanks. Oh, here comes King David again, everyone.
Speaking about the federal investigation, when you were not a part of it, and talking about why a federal grand jury was convened, what they were investigating, what they found or didn't found, is complete speculation. Should not be a part of this argument. We don't know. It didn't prove anything. It's not as though they came up with a statement exonerating anyone. So that should not be considered by the court. With regard to the two cases that Mr. Brennan cited, you'll note that in one, he talked about the exclusion of hearsay evidence. There's a different standard when you want to introduce hearsay evidence as part of a third-party culprit defense. There need to be substantial connecting links to the crime itself. The court ruled in that case there weren't. In Finney, there were. And with regard to the other case, well, I'm sorry, that's with regard to hearsay. With regard to the other case, that was the exclusion of past assaults to show that somebody was violent. Again, Commonwealth v. Conkey is a case where they said, well, that should be, in addition to a normal or a regular third-party culprit defense, you should also be entitled to that evidence. So that's not very instructive. The other two things I just wanted to point out, because I did not mention them, Your Honor, is that Brian Albert also disposed of his phone. We'll never know what was on that. That's further evidence of consciousness of guilt. And then an important point is that the pile driver, Mr. Laughlin, went by the house at 3:30 in the morning and saw a Ford Edge parked in the very area where John O'Keefe's body was found. And we know from the evidence that the Alberts, both Brian Albert and Colin Albert, owned a Ford Edge. So that is in the mix as Unless the court has any questions, I would just want
Hi, thank you very much. So let's go on to paper 620, the Commonwealth's motion for production of records regarding Unsolved Productions.
So she's not going to rule from the bench, you know. Okay, we're moving on. Moving on, everyone.
Yeah.
Yes.
Your Honor, the Commonwealth filed a Rule 17 motion for records from Unsolved Productions. It has been discussed briefly in court. At times during argument, there was a so-called documentary that was aired in a 5-part series. It gave a inside, behind-the-scenes look of the defense team and Ms. Reed as it prepared for the last trial. This 5-part docuseries produces a number of statements from the defendant, many of them extraordinarily relevant, some of them from the Commonwealth's perspective extraordinarily incriminating, and many of them inconsistent with statements made publicly in the past, including Dateline 2020 and Gretchen Voss. We served the local service in Boston, a local agent. The record holder is the producer of the series, and they have been notified. If the court allows this motion, I expect they will provide the information to us by the end of the week. I understand there is probably over 200 hours of recorded interviews, and we expect to use a number of those statements at trial. We have statements of the defendant. They're admissible substantively.
Did they appear? Are they here today to be heard?
They're admissible to show contradiction to other statements. And so they are material and relevant. I understand the time frame. We haven't had the privilege of seeing them. The defense was there for a part or most of it, but we will use the time we can to sift through. We're not looking for a continuance or additional time to look at the materials. We'll look at them as we prepare for trial. And so I'm asking you to grant this. It clearly makes the Rule 17 standard material relevant. We don't have access to these before trial. We won't be able to prepare for them if we get them pursuant to a trial subpoena. They've been properly subpoenaed and they are forthcoming with the court order.
There's no one here from Unsolved Productions.
There is not.
They're entitled to be heard. Did you notice them?
Your Honor, we're aware of the communications back and forth between Commonwealth and the production company. So we've not been privy to that. This is the first we're hearing of any communications that they've had with the production company. I think obviously in abundance of caution, they should be given an opportunity to oppose if they wish. Nothing officially been filed one way or the other. So we're not in a position to argue on their behalf for sure.
Right.
So, we have 2 things left to discuss. I want to talk about general empowerment.
Okay, we're a little bit behind, so if we're ahead in another stream, please don't spoil it for everyone else. Also, I know that Boston 10, I think, is streaming, but they were way behind when we tuned in because this feed was cutting out a little bit. Yeah, did they not appear? Did she say whether it was granted, or did she just say, I mean, listen, he tried to pull a fast one the other day when he had that other Rule 17 hearing for Aiden Carney's records and didn't tell Karen Reed's team that motion was on. So did he properly notice defense counsel? Because you know the media is going to show up. They don't want to give up their stuff. There's no journalistic privilege in Massachusetts or shield, but they want to be heard on it, I'm sure. I don't think she said whether or not she granted it. I just want to hear what she said again.
We have 2 things left to discuss. I want. All right.
Taken under advisement.
So, we have 2 things left to discuss. I want to talk about general empowerment. We also have a Commonwealth motion regarding Mr. Yannetti's. Mr. Yannetti, it's 10 past 12. Which one do you want to go forward on first? Do you want to talk about the empowerment, or do you want this motion?
I'm not going to leave with those.
I understand, but do you have a preference for some before lunch? All right, so let's do that motion. Commonwealth's motion to compel communications between the defendant and the attorney.
All right, here we go. This is the attorney-client communications. Is this a new court reporter today? What happened to Madam Court Reporter? She's also holding a different thing up to her mouth. It's not the regular athletic cup. Oh, where's Madam Court Reporter? I hope she's okay. They want text between David Yannetti and Karen Reed.
Your Honor, so I'm clear, the Commonwealth is not seeking all communications between Ms. Reed and Mr. Yannetti. We're only requesting the communications that may be on any type of records in the possession of the Commonwealth. And specifically, there are phone records which have been redacted, and I do not know was underneath those redactions. And we believe we
We
have
know.
an entitlement to the information in the narrow area where Ms. Reed has waived her attorney-client privilege. Specifically, where the defendant intentionally divulged the content of her communications with Attorney Yannetti about liability and potentially striking John O'Keefe with her car. Those subject areas in that narrow time frame are no longer privileged because they're now public. The Commonwealth has identified a very narrow window, and that's a 3-day period. And that is what is mentioned by Ms. Reed in her public statements, that she spoke to Mr. Yannetti and she thought about it for 3 days. We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area in which where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related. This is made in good faith. Anything that is non-privileged is open to the public. It's not confidential. There are 2 communications that Ms. Reed made publicly that we assert waived the attorney-client privilege as it relates to that issue. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023, and the transcript is page 105, line 23.
Was that before or after she ate psychedelic mushrooms with the not-so-confidential informant, Kay Peter? Thank you, Cynthia, 1880, for gifting 10 memberships. Love you, girl.
She was asked the question by Ms. Voss, you never said, did I hit him? I hit him. And the answer by Ms. Reed was, I said, did I hit him? Question mark. And then, when I talked to David, now this is later, David said, Karen, if you incapacitated him in any way, there's culpability there. And I thought, all right, maybe this is maybe I said to my mother, just to go forward for a second, they were asking me, what was it like? Did they come out? What was the house like? Similarly, in the documentary series, Ms. Reed is video and audio taped, and it was presented on television, that she said, and then when I hired David Yannetti, I asked him those questions the night of January 29th, like, David, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about it for about 3 days. And so that is where I get the time period regarding these relevant statements, admissions by the defendant about her state of mind and her interaction with John O'Keefe in her vehicle. These statements were made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege as to these communications in this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential. Even if it was inadvertent or overheard, it would still waive the privilege. This is entirely different. There can be no doubt that there was an intention to pierce that attorney-client privilege for whatever benefit the defense thought it gained them. If this was intentional, it wasn't secretive, it wasn't overheard, it was a...
You think she intentionally gave up her attorney-client privilege? Did he really just say that she intentionally did that? Did he mean to say she inadvertently did that? This is she's orchestrating this to pierce the attorney-client privilege? I got to hear that again.
That there was an intention. It would still waive the privilege. This is entirely different. There can be no doubt that there was an intention to pierce that attorney-client privilege for whatever benefit the defense thought it gained them. If this was intentional.
It was intentional that she waived her attorney-client privilege because she was going to gain an advantage? Make it make sense?
It wasn't secretive. It wasn't overheard. It was a exacting and purposeful engagement. So we ask you to review the cell phone extraction, any text or emails that may be on those extractions, and relative to that short window, relative to this specific area, anything that is waived that is no longer confidential, we believe we're entitled to. It's obviously would be relevant if it's narrowly related to these statements, and we would use that at trial. Thank you.
Well done, ex parte, not today.
I am, Your Honor.
Yes, Alessi. Yes, Alessi. You don't messy with Alessi. Thank you, Mrs. Bouquet. On top has his tinfoil hat on today. Thank you for your super chat.
May it please the court. The Commonwealth concedes throughout its motion, as it must, that the communications it seeks to intrude into are privileged communications between Ms. Reed and her attorney, Mr. Yannetti. 2 of the 3 instances of the communication they cite to are over 9 months old, and that's in 5 months old respectively. So you have 9 months ago, the Gretchen Voss statements, and 5 months ago, the Vanity Fair statements. But they waited until less than 2 weeks before the start of the trial.
Apologies, but the closed captions on this feed are not working. Sorry.
To bring this momentous and potentially far-reaching and consequential motion. Why? The courts are clear that they take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privileged communications this close to trial. The Commonwealth does not explain their delay in raising this issue this close to trial. With regard to the 3rd communication, the HBO Max one, it regards the same event that is discussed in the first 2. There is no addition of an event in the 3rd one. So that 3rd discussion, the docu-series, regards the same events that have been extant in the first 2 that have been extant for 9 months and 5 months. The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does. As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client, are canonical examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege.
Sacrosanct.
In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest of privilege for confidential communications known to the common law. And this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context,
I mean, I'm so glad he brought up Shakespeare because we've been calling her Lady Macbeth for a long time. Shakespeare has entered the chat. Thank you, Christine, for gifting 5 memberships. Love you with all of my heart.
of criminal circumstances, the privilege has constitutional dimensions as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Goldman case 395 Mass at 502. And it bears underscoring the basis and the depth of the intrusion is a quote from the very case and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions, just one. Matter of a John Doe grand jury investigation 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that the potential is inconsistent with the traditional value our society has assigned. Here's a key point. In the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites the Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in our, not a factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is now limited, but I'm not going to give you this information, Mr. Brennan. I don't even think it's.
She's not allowing
So
it.
motion's denied.
Motion denied. What? Big W.
Thank you, Your Honor.
Big W. She's like, Bobby, baby, Bobby, baby, Bobby, baby. You don't even need to go any further, baby. You don't need to go any further. Motion denied. I'm not giving it to them. Even she knows that this is so far over the line when you start interfering with the attorney-client privilege. She's like, you know what? I'm going to stop you. Like, I've heard enough. No, you're not getting it. Next thing. Let's get this done before lunch. She's on it. That's a big win. I don't think there was anything in there anyway. A lot of people have been arguing over the weekend about whether or not she did voluntarily waive the privilege. She's not giving it to him anyway. Ding, 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 ding. Big W. Big W. Let's just revel in that for a second. We're moving on.
So,
Victory tastes sweet, doesn't it?
Sometimes you need 5 minutes.
Bodies need 5 minutes. Yeah, the judge hasn't found the mic today. I don't know. New court reporter, new athletic supporter. Look at it. Yannetti's like, you did it, dude. You did it. We know there was nothing in there because we have the email. We have the email from Eliza Little to Adam Lally before the first trial where she says, it was like in 2023. We know that the taint team found 2 communications to a lawyer named Jack Diamond, and that's the only thing that the taint team found. We know this from 2023, and apparently Hank Brennan does not because he didn't read his file. All right, their 5-minute break is over. I'm going back to court.
All right, so I looked at the proposed supplemental questionnaire, they're very similar. So I have a question.
All right, they're talking now about the jury questionnaire. Let me see if I can get closed captions on this other feed. And it's not working on NBC 10 either, the closed captions. But the audio might be a little bit better. Hold on. All right, so they're going to talk about the jury questionnaire. Let's just flip to, we're on channel 5. We're going to go to channel 10, see if this audio is better, even though we can't get closed captions anywhere.
Questionnaire, they're very similar. So I have a question. So the Commonwealth on your number 5 on the first page. I don't like the 2 questions in a row, 4 and 5. I don't think we need 5. Is that okay with you, Mr. Brennan? I don't think we need both.
It should be done.
So that's out. So I'll go through, actually, I'd like to go through the first page of each. The first page of the defendants, number 13. Do you believe law enforcement officers are generally fair and accurate in their investigations? Who's arguing this for the defense?
I can argue it.
All right, so I don't have a problem with that, but it makes sense that we put it after 8. Those series of questions.
No objection to that.
All right, any objection to question number 13 and putting it at 9, Mr. Brennan?
I don't have any objection to moving it after 9. I think it's a bit one-sided. It leans towards, one-sided, but I don't have a strong objection to it.
We can balance it if you want to suggest some language.
If there's an invitation to balance, I'll need a moment.
All right, so you can suggest something at some point. All right, so now moving on to the second page. The Commonwealth's number 17 seems appropriate to me, but if you were working for the same document that's not in the defense when it was removed, I guess, is there anything about crash reconstruction testimony that would make it difficult for you to be fair and impartial in this case? I don't have a problem with that question, does the defense?
We didn't have a real objection to it, just wasn't a particularly useful question. We thought of the last trial, everyone said no, so in furtherance of trying to have additional space for more helpful questions, we just decided to exclude it.
All right, I think we'll keep it. There's one I do want to get rid of, that caused problems last time, but we'll talk about that in a minute. All right, so thank you, so.
She just gave Eliza Little a win that she wasn't expecting because she was willing to withdraw the question from the jury questionnaire, and she said, no, I'm going to keep it. Could that be 2 wins for the defense today?
Question number 23 on the defense. Does the Commonwealth object to that question? I think it needs to be tweaked at the least. This little.
We do.
All right, so what's the objection?
I think the question, the way it's written, invites a juror to potentially not follow the judge's instruction. And so I understand the attempt, the idea of it, the germ of it, but the way it's written, it invites, I think, a jury to, or a juror to usurp what their role is.
And what do you say, Ms. Whittle?
I think if we just tweak the language a bit, I mean, we're happy to hear some proposals from the DA as to sort of the particular issue they have with this question. But I do think the question about the judge's instruction regarding, you're entitled to your own independent individual verdicts.
So they're always told that their verdict must be their own. So there's language in there's probably language in my preliminary instructions, there's language in the charge, certainly. So if it mirrors that language, I don't have a problem with it. Otherwise, I might. So
We can mirror the
talk to each other
the
about
proposed
that.
charge.
All right, so,
We would agree to that as well.
okay, thank you. Number 25 in the minutes. If you had to vote today on whether Ms. Reed is guilty or not guilty of the crime charged, what would your vote be? I tell them throughout the trial, they're not to speculate, they're not to make up their minds until all the evidence is in. I'm not going to even suggest that this is appropriate. So I'm not going to include that. There are enough questions on reasonable doubt, presumption of innocence, and defendant not testifying. So that's out. So the question, also, is there any reason why you do or do not want to serve on this jury? I don't think we should invite them to decide whether they want to sit in this jury or not.
Just because you probably can't hear her, the question proposed is there any reason why you do or do not want to sit on this jury? And she doesn't want that question to be asked. She doesn't want to invite a response for that.
This last time, I don't know what the responses were. Does anybody have any information on that for me?
I think most of them were no. I think 27 kind of hits the same sort of, if
Right,
you have
if that-
general concerns about the case, so I don't have a strong objection.
If that's what we're getting at, we've got it in 27. So I'm inclined not to put it on there. Again, I can hear from you beforehand, probably in writing, I don't want to bring it back.
May I alert the court's attention, there's 2 on the first page that were slightly worded differently in the Commonwealth's proposed questionnaire and the defendant's
Oh, okay, which
proposed
numbers?
questionnaire. If the court looks at number 4 on the defendant's questionnaire, we had kind of combined the Commonwealth's proposed questions 4 and 5,
Yeah,
so that's one question.
so that's, and I just got rid of Commonwealth's 5.
Perfect.
So this one's better, so we will use that.
Okay, and then number 7 that was proposed by the defense, that is the same, similar question as number 8 in the Commonwealth's proposed questionnaire.
Yes,
It's just different language.
I thought it was the same.
So we changed it to say, when you tend to believe or disbelieve law enforcement officers, firefighters, or first responders more than a civilian witness simply because of their occupation, as opposed to automatically believe.
So we typically ask you automatically, what's the Commonwealth's position on this?
I have a strong preference, I'll defer to the court.
All right, so I will think about that, Ms. Memo.
Thank you.
All right, so the question that I don't like, and you may remember, causes a lot of jurors to say, I have no idea what you're talking about. 21 on the Commonwealth's, 20 on the defense. So you may find a defendant guilty based on circumstantial evidence, but you cannot find a defendant guilty based on speculation, guesswork, or surmise. Is it difficult for you to understand the difference between circumstantial evidence, speculation, guesswork, and surmise?
I'm sorry, can you repeat that?
It's your number 20. I'm not gonna read it again.
I'm not going to read it again. You should have been paying attention.
It caused a lot of trouble before. I think in every single one, I had to repeat myself with the instruction that I gave in anticipation of this. I gave them a pre-charge on circumstantial evidence and not being able.
Yes, just the way that it's phrased in the Commonwealth's questionnaire, it makes it seem that the Commonwealth doesn't have to meet their burden of proof.
I think it should be omitted completely.
I have no issue with that, it's just the way that it's
Does the
phrased in the
Commonwealth?
Commonwealth's questionnaire.
It's too confusing in my mind.
Okay, it took out, if you remember, it took out an inordinate amount of time, virtually every single juror.
We have no problem with that.
All right, so that will be omitted. All right, so that's that. Ms. McLaughlin, I think you said, and I think I cut you off the other day, that the third page was right from Chisholm. I reread Chisholm on 95 pages of it the other day, and I didn't see it. Where does this third page come from? The publicity one.
The questions come from Chisholm, that were asked in the juror questionnaire. The other, some of the other cases, questions were part of the juror questionnaire of the prior trial that just moved over to this page. So this page dealt with a questionnaire exclusively answering questions.
Ms. McLaughlin, the Little Mermaid, has found her voice. She's found her voice today, and Liza Little's on fire. I'm glad she's getting her, she's on it. She's getting her comeuppance a little bit today, and I like to see it. Did Septic Hank's tank of pathological lies, did Higgins just say that did he say that Higgins was just cleaning off the cars, not moving them? Thought he said he was moving them. Maybe he didn't. Yeah, Lally's the bag carrier. He's the water boy. But now that he's in hot water for hiding the videos, I'm calling him Hot Water Boy.
Okay. All right. I think that we all know many, if not most, and perhaps all potential jurors have heard about this case. Giving them the opportunity to write the details that they would call down may take an awful lot of time and space that we don't have on this form, and frankly, I don't think we have. So what are your positions on, what's your position on 3?
Your Honor, if I may, I can just hand up the excerpt from the Chisholm case that outlines the.
All right, I'm not sure 2 lines are enough space for it, frankly.
There are 13,666 viewers in the chat right now, which makes complete sense. Smash the like button, help a girl out, helps the algorithm, helps people learn about this case who are not familiar with it. And people are asking, what can we do? What can we do? We can get the word out. We can get more people to pay attention to this case and this ridiculous, insane, wrongful persecution.
Do what we can do. I didn't realize it came directly, same language. Okay, looks like we're giving this third page of the questionnaire. Yes, Mr.
Your Honor, I want to bring the court's attention something that the court and counsel just discussed. Question number 7. Could I ask the court to direct its attention to
All right,
question?
which page?
Sorry,
Third
on
page or previous page?
the defendant's questionnaire on the first page. That was the question. I think the court's going to consider whether to use the word automatic or tend to.
Yeah.
I believe that should be broken into 2 questions. It doesn't tell us anything. For instance, the way it's written in the disjunctive, would you tend to believe or disbelieve law enforcement officers, firefighters, first responders, more than civilian witnesses, just simply because of their occupation? If someone says yes, we don't know if that's believe or tend to disbelieve. So I think if we just break it into two questions and now we've got the space to do it, that would be more instructive.
Why does it matter if it's an automatic belief?
I'm not worried about the automatic part, it's the believe or disbelieve. That's the part that doesn't help us.
Right, so if it's automatic, simply because of a person's occupation, this juror would automatically either believe or automatically disbelieve. How does it make that person a fit juror? Why do you need it?
Because that tells us, it would instruct me at least, it would enlighten me on how to further question that juror. If someone says, well, I'd automatically disbelieve police officers, or I'd automatically believe police officers. Those are two very different mindsets.
So I understand that. I'll consider it. I think we keep it as one, and then if they say yes, we acquire it.
Okay.
Maybe. Let me see.
Okay, thank you.
All right, so it looks like we have the third page as well. I think, I have the statutory questions that I would ask with Vinay, right? If we take that question that Mr. Jackson just talked about, I can ask each individual juror, if I use the tend language, if the testimony were in conflict, would you tend to believe the testimony of a police officer more than any other witness simply because he or she is a police officer? And then conversely, would you tend to disbelieve a police officer simply because he or she is a police officer? I typically do that at sidebar in every case asked exactly like that. So it makes more sense to me that we do it that way rather than a questionnaire, but if you want it on the questionnaire, we'll stay as is. So what's your preference then?
That would be the defendant's preference.
Do you care, Mr. Brennan?
We prefer a questionnaire.
All right, so I'll think about it, I'll do it one way or the other, and you'll know next week. So one of the things that I was considering doing, so we have a lot of jurors coming in next week. On Tuesday, 218 jurors have been summoned, is my understanding. We will get some portion of that, we will get some fraction of that maybe, just on how it goes with whether people are here and available to testify on that date. I mean, to serve as jurors. So say we get like 150 or 175 jurors. I have my remarks to sort of just direct them to what their job is, as you remember, and then I leave when I give them the questionnaires. My guess is for the jurors to fill out this questionnaire, have the questionnaires collected and copied, might take an hour and a half or 2 hours if we have a really large number of people. What I intend to do, at least on Tuesday, is have all the jurors fill out the questionnaire, however long it takes. And depending on how many jurors we have and what time it is, maybe take 50 of the last jurors or so, send them home and have them come back the next day at 11 o'clock. If we've got fantastic court security here, hopefully we've got a courtroom to keep people in. There are a lot of things we have to juggle to get this done, and I don't want to waste jurors' time. So I would send them home, have them come back the next day at like 11, so that then the next day's jurors at 11 o'clock can spend that hour and a half, 2 hour process, filling out the forms, having them copied, given to counsel, and we can continue on with those jurors. So it's something we can decide on Tuesday when we see how many people are here, how many jurors we get, how many jurors the district court needs. But is that a process that you would be willing to do? Mr. Brennan?
Of course.
No objection.
All right, so we'll try and figure out something that way to get things moving that way. All right, the list of witnesses, you both have a list of witnesses. I told you you needed to combine them so that I can read that to the jury and state the case to the jury. Do you have that yet?
We are not combining them.
All right, so I need you to look at that, and a statement of the case to read to the jurors. It's all part of the final trial conference. So I should have had it last week. So I need that by Thursday. Is there anything else we need to discuss today?
Yeah, the motion to dismiss. Are we having a hearing?
There's still a few outstanding issues. One is ARPA.
Where do you stand with discovery on that?
I received some two letters last night. It is not the information I was seeking from my motion that was allowed by the court. And so I have grave concerns about waiting for the day before their testimony to pursue.
Oh, now he's got grave concerns. He had to throw that in there. Grave concerns. He's got grave concerns about ARCA. He hasn't been provided with anything. He's got some TUI letters that apparently were non-responsive, and he wants the judge to rule that ARCA will not be allowed to testify. Yeah, he's got grave concerns. How about the motion to dismiss? Are we going to rule on that? Are we going to have an evidentiary hearing about jury tampering and whether Fanning was in contact with the jury and who told Fanning that the pro Karen Reed juror was talking about the case in the bar? Then he told the court, like, game of telephone without a hearing. Are we going to talk about that at all? Or, you know, the fact that they've been withholding Sally Port Brady evidence for 3 years. Are we going to have any sort of a decision on that? Because you're full steaming ahead to pick this jury next Tuesday. See you next Tuesday. And you're expecting, you have 218 jurors coming in, potential jurors. You're expecting maybe 175 might show up, maybe 150. And it's going to take a while to pick this jury. But are we going to decide about the motion to dismiss, or we're just going to listen to him whine a little bit about ARCA? He wants to keep out every single thing that does not, that shows that John O'Keefe was not hit by a car. Grave concerns, they do. Marcy was the first one to say grave concerns when he wrote that email from his private email server to all the Stoughton court judges, you might remember.
Is not the information I was seeking from my motion that was allowed by the court. And so I have grave concerns about waiting for the day before their testimony to pursue the other discovery.
He doesn't want to wait to the day before their testimony, because that's what she said. She would save the voir dire until the day before their testimony. She didn't want to call them in this week. So, Mr. Jackson, what do you have to say to that, Mr. Jackson? Did you take the red eye, Mr. Jackson?
Your Honor, I do not know what Mr. Brennan is referring to with regard to what he's looking for and grave concerns. The hyperbole is unnecessary.
So there was a motion allowed, so that should be able to, there was a motion for the discovery allowed a while back.
It
So that
was,
should narrow.
Right.
Right?
pardon me?
That should narrow things.
It does, and we have not, I attempted to confer this morning with Mr. Brennan, and my recommendation to the court would be for us to confer further, because I just don't understand what he thinks is out there, but we haven't conferred fully either.
Okay. All
He
right,
won't
so
confirm.
do that. We can address this next week. I think we'll probably have plenty of time to sort of tie up loose ends during the impanelment process, because I think it's going to take a very long time to get a jury.
Understood. And I expect we'll file a response to a proposed expert who received their report last night. And I didn't receive it until later, which I want to have a chance to respond to.
And Your Honor, if I could, please, one more item when it's appropriate for Your Honor.
That's okay, go ahead.
Thank you. We did receive the, Your Honor may recall the argument over Dr. Welcher in Your Honor's direction request, and then the assent of the Commonwealth that they would redo what they had provided, that 140 slide presentation. We
PowerPoint.
did receive that, but we received a lot of other material in addition to that,
Oh.
megabytes. I haven't even been able to open it up.
Trial by ambush much? Really? The judge told you to pare down the 140 slide PowerPoint presentation, and now he decided also that he was going to turn over a whole bunch of more stuff, kind of like the Sally Port video. Listen to this.
In addition, we received that, provided that 140 slide presentation. We did receive that, but we received a lot of other material in addition to that, huge megabytes. I haven't even been able to open it up. It takes so long to open it up. I respectfully request that we, Your Honor, grant us please 2 more days than what we had to take a look at that. because it's just taken an extraordinary amount of time.
Wow, he can't even open it up.
I can be clear, there's no new information. What Mr. Welch did is that all the information he basically gave his opinions on was in the gigabytes we provided to the defense, but he wanted to make it as seamless as possible, so they'll effectively hold their hand through it. He put each site under each slide so they can find it in the file folders exactly where it is. So it's instructive and helpful, but it's not new.
It's instructive and helpful, but it's
Sure,
not
if I
new.
may, I don't disagree with Mr. Brennan's characterization. However, it is still 140 slides or so. I was expecting a rather substantial narrowing, so what we have to do is we have to go, and unfortunately, I think Your Honor is going to hear similar points that we made, but it's going to take more time, because I had the expectation, maybe unreasonably so, that it would be a narrowed slide presentation. So I'd appreciate the 2 extra days.
All right, so when does that put us at? What was the time frame originally?
I'm sorry, Your Honor, I don't have the specific date handy right now.
The time frame as far as the response,
Yes.
well, we were supposed to exchange discovery yesterday. And so I had that presentation sent over last night. They sent over the 2 letters.
Yesterday, but you sent it over last night because, you know, he's tattling now to mommy. Mommy, he's the tattletale everyone hated in elementary school. Tell me that the weasel does not kind of look like him on the thumbnail. I'll allow it. I mean, I'll allow that it does look like him because it really does. It's uncanny.
Have you seen their dog experts report?
If I could, Your Honor, I maybe Attorney Brennan misunderstood the question.
Wait, he's talking about Garrett Wing. What did he say? He did not get their dog expert reports. Find the mic, like a man, or project your voice because you got your back to everybody.
If I could, Your Honor, I maybe Attorney Brennan misunderstood the question. He is correct that he provided us with the presentation last night, but the question, I believe, Your Honor, was when was our time? Because Your Honor had given.
Wait, I want to know what he said about the dog expert.
I
Right?
had that presentation sent over last night. They sent over the 2 letters, and I've received their dog experts report.
Oh, he did get
If
the
I could,
expert
Your
report
Honor,
on
I
Garrett Wing.
maybe,
Good.
Attorney Brennan misunderstood the question. He is correct that he provided us with the presentation last night, but the question, I believe, Your Honor, was when was our time? Because Your Honor had given us time to respond, and I apologize, I don't have that date, but what I'm just asking for is 2 more days beyond it, but.
I don't think I gave it to you.
Yeah.
So you have 2 days to respond to that.
I have 2 days from today.
Yes.
Okay.
All right. So there are a few matters outstanding. I will have the decision on the motion to dismiss, should by the end of the day, buffer zone.
Oh, by the end of the day, we're going to get a decision on the motion to dismiss. We might be here all day. Hang on. It's already been typed. Hang on. Did I hear that correctly? Could it be? I guess we're not having a hearing.
Should by the end of the day.
Right.
The decision on the motion to dismiss, should by the end of the day, buffer zone.
By the end of the day.
By the end of the day.
Buffer zone by the end of the day.
And I'll get everything else done as quickly as possible.
Okay.
Anything else?
The only other thing is the logistical issue as it pertains to both the voir dire process as well as during the trial. I wanted to ask the court if there was a mechanism by which Ms. Reed could have at counsel table some sort of an earpiece or headphones or something
Yes.
that's slaved to a microphone up at the bench at sidebar so that she can listen in on both. It's very.
She can come to sidebar. Ashley Benefield had that. Remember, Ashley Benefield had headphones that she was listening to sidebar conversations. I'm sorry, my mic is loud. It's not me. We've tried to adjust the volume several times today. They lost the mics at the end of this, so apologies, but nothing I can do. Can't please everybody. Ashley Benefield had the headphones on, right? Sarah Boone might have had them too. I don't remember. Yeah, in Florida, it's pretty standard. Okay, let's hear it.
I want to avoid that if possible. It's clunky. Especially during the voir dire process. I think it would be uncomfortable, and quite frankly, I think it would be a little inappropriate to have jurors with Ms. Reed standing right there with them and with us.
It's done all the time. It's not
It makes
It's
it all the
done all
time.
the time.
Maybe something you're choosing.
She's like, it's done all the time that the defendant comes to sidebar. Really? You can't give her a pair of headphones? Really?
It's not
It makes it all the time.
It may be something you're choosing not to do, but she has every right to be there at sidebar. So you say you don't want that, you want some accommodation. I don't know if we can do it. I'll think about it.
We could,
Really? Can't accommodate. It's all about a fair trial for the Commonwealth, you know? Thank you, Orwellian
one of
person.
the things that we were talking about is potentially a closed circuit wireless microphone up at the bench and a set of headphones here that she could listen in.
Put it all in writing. I
Okay.
would like to have had before today, and then moving around.
Oh,
courtrooms.
put it all in writing. Put it all in writing. I would have liked to have had it. We would have liked to have had a decision on the motion to dismiss before today, Your Honor, as well. He can't say that now because, you know, he's on thin ice and whatnot. We would have liked to have a decision on the motion to dismiss too. Welcome to Massachusetts in the courtroom of King John Canone. Although she has been pretty fair today, so I might take that back for a few minutes.
She can come to sidebar for any sidebar discussion, impanelment, whatever. It's her absolute right. If she chooses not to do so, I'm going to need you to tell me that.
I'll put something in writing and perhaps I've got the plan in the back of my head. I'll put it in writing. And
We have a lot of different equipment that we need to make sure has priority. It's in the
Understood.
courthouse, so I'm not very hopeful that we can accomplish this in the next few days.
Okay, well, thank you for entertaining.
He's being on his best behavior.
One thing, when we get the juror questionnaires, the supplemental juror questionnaires that we talked about, and I need you both know what our decision is here, other than the 10-2 versus automatic. Let's go with 10-2. And I can either do that in sidebar or in the form. What I'd like you to consider, and lawyers have done this in other cases that I've had, is if there are answers that are clearly what you believe would both sides agree jurors excused for cause. In an effort to be able to go through this vast amount of jurors that the jury commissioner's office was kind enough to summons in for us, if things stand out to you, it would be ideal if you could agree that jurors number 8, 12, and 16, both sides agree should be excused for cause based on the supplemental questionnaires. It would be very helpful if we could do that. And maybe keep a running sheet that would be a joint proposal to excuse these jurors for cause. It may happen when you look through the questionnaires on folks that we sent home to have them come back the next day to just call 5 people. The court officers call them and tell them not to come in based on the questionnaire. So please think about that. It makes sense to me. It was very helpful when lawyers were able to get along well enough to do that in case that we.
That was a dig. We have a shovel emoji for that. That was a dig. It was very helpful when lawyers were able to get along and agree on things. But I think she's realizing that Hank doesn't like to play well in the sandbox. And he'll keep tattling. What you allow continues. Judge Canone.
Get along well.
Wait, listen to that again.
And tell them not to come in based on the questionnaire. So please think about that. It makes sense to me. It was very helpful when lawyers were able to get along well enough to do that in case that we tried, that we had changed venues on because of pre-trial publicity also. All right, anything else?
No, thank you.
Your Honor, there was a motion for reconsideration that was filed with regard to the metadata underlined. I can.
You can make an objection. Go ahead.
I just wanted to make sure that the court saw that motion and that it was filed. I don't know if the court wants to hear a full argument, I'm happy to do that, but we just wanted to make sure that that gets decided.
Okay. All right, there's still a few outstanding.
Thank you.
There's still a few outstanding
Anything
motions.
else?
Not from this mission.
All right, we'll see you on Tuesday.
Court, please.
See you on Tuesday. See you next Tuesday. She didn't want to say see you next Tuesday. She said see you on Tuesday. You might want to readjust your volume now because the volume in court is going to go off and we are going. We have a lot of other things to talk about. So there are a lot of motions. Outstanding, but she's only going to decide the buffer zone motion today, and she's going to decide the motion to dismiss by today. Everyone smash the like button. And that's all she's going to decide today. So we will hear those decisions today. So we will be back at some time. So if you're not sticking around for the questions, make sure you smash the notification bell on your way out. Make sure it's set to all notifications, because as soon as I have that in my inbox, we will go live again. Thank you to Kay Willis for gifting memberships. Kay Willis, if you is a realtor south of Boston, if you'd like to sell your house and get the hell out of Massachusetts, she's your girl. Kay Willis is a realtor. Thank you so much, Kay. And Charlie Raven also gifted a membership. Thank you so much. Suze says, thanks for the 5. And also, wait, one more. Ex parte, not today. So that's what Karen Reed is thinking today. Ex parte, not today. Like they tried to do last week with that ex parte hearing. Sue says that they did not properly notice the production company. He sent it to the registered agent, which is incorrect. I think he did that last time too. He did that another time, and he had to reserve, and then they did show up. So he doesn't learn from his mistakes. It's kind of like every day is a new day for Mr. Brennan. So thanks, Suze. I had a feeling, and I think also that you worked in process service at once, right? At one time, right? Or maybe even now. M. Monge said, I heard on Court TV this morning, Turtle Boy is not allowed in the courtroom or to watch the trial. Court TV often gets things wrong, so I do not know. He is on the witness list for the Commonwealth, and that is typically what happens. However, you never know. If his attorneys are going to make a motion, Gretchen Voss was allowed to come in. They gave her a special dispensation. She is a reporter as well, but she was also not facing witness intimidation charges. So I don't know. Court TV is never right, so please do not believe everything they say. Are we ignoring the motion to dismiss? Nope. She said she would rule on it by end of day. COB, as it were, close of business. Lady, thank you for the 10, said, is there anything that the people of Massachusetts can do to get rid of this corruption? This is scary. Yeah. You can share it out. You can get people interested in watching this case. The world is watching. Hit the like button. It helps the algorithm. It helps push the stream out. Also, you can share the stream on your own end on whatever social media you're on. That helps. And also vote in your local elections. Very, very, very important. Tammy says, can we talk about the 2 to 3 different male DNA samples and the injuries to Brian Albert and Colin Albert are also proof? Give me a break. Take DNA from Brian Albert, Colin Albert, and Brian Higgins to clear them. Do it. Yeah, they're never going to do that. They're never going to do that, and they're never going to be forced to give up their DNA. And apparently, I've been told that perhaps the samples that they had were not enough for testing, or they were insufficient concentration of 2 male donors of DNA for testing. And so perhaps that is why they didn't test it. But again, without samples from the other people in the house, they wouldn't be able to test it for anything. Anyway, Rainy Day, I asked how long it took those knuckles to heal. And she says, a patient with knuckle injuries, you have a patient who it's been 4 weeks and the knuckles are still not healed. There you go. When was that picture taken? I have questions. Jade, what about the Boston's finest outtakes and Brian's incriminating footage? Yep. Goes to his violent propensities, but we don't know if it's going to be allowed in. She took that under advisement, that whole motion. Sham Wow says, I have a vague memory of Chloe being removed from the house that night. Colin comes to mind. We don't know. There's no actual proof of that. Were you there? Sue says that Lank said that he did not see or hear a dog when he went in the house on January 29th of 2022. He did say that under oath. They asked him. I don't recall that. But thank you. That's good information. Kimberly, I wanted to bring this question. The data shows that John O'Keefe went up and down stairs 3 times. Where are there stairs by the flagpole? There are not. You know who also said that he went up 3 flights of stairs when he got home? Colin Albert. Why do you think he said that? The Commonwealth knew that John O'Keefe's Apple Health data has him going up and down 3 flights of stairs right after Karen drops him off. Was Colin Albert worried that they might have his Apple Health data too? And that his Apple Health data would show him going up and down 3 flights of stairs at the same time? Because remember, he said he got home or he left at 12:10. He left at 12:10 or he got home at 12:10. Refresh my recollection. Chatters. I have questions. Was he worried? Was he worried that they were going to get his apple health? Was somebody else worried on his behalf and said, tell him you went up and down 3 flights of stairs? I wonder if it matches. I don't think we have it. He left at 12:10, says Olivia. But I have questions about that. How did Brian Albert mess up his arm and shoulder at some point between leaving the bar on 128 and the next day, 129, to end up in a sling? I know there's photos out there. I don't know if we have proof that they were taken on January 29th. Somebody also said that he might have had a planned shoulder surgery, so you can't speculate about that or when those pictures were taken. Hank's whiny objectifications says once it's proven John O'Keefe went in the house, game over. Yep. ARCA paid for by Proctor's career is here. Thanks for the 20. Waterfall footage is riddled with AI clips copied from CF McCarthy's. Defense's new data will show a very different timeline. And Lil Colin in that 12:10 a.m. time frame they all test to is a lie. I saw that on Twitter. Somebody put a video of John O'Keefe outside the waterfall side by side to the video inside CF McCarthy's. And it's like the exact same motion. It's weird. I don't know enough about AI and video editing to opine on it. So there are people who really do that on Twitter, and that is their career, and that's what they do. And so you can find it. Mick fabrication of evidence. Higgins stretches his foot out and puts it on Karen Reed's chair in the waterfall too after the practice fighting. I didn't notice that. Thank you though. Storm Dancer says, does B not realize that there were things called duels back in the day? They were done for many things, including the affections of a woman, right? The duels. Brennan forgot. I guess he doesn't realize that a woman could be a motive, or drunk guys could just fight for no reason, or make a beef out of something that was just a little beef. And then once you're drinking all day, it becomes a big beef. And because, testosterone, and sometimes you just got to get a punch in. I don't know. I don't think whatever happened inside the house was intentional. It may have very well been accidental. He may have took a hit, and he may have fallen backwards and smashed his head on the weight bench or on the bars out of the weight bench. We've looked at the weight bench several times, and the wounds could look similar. You decide. If you Google 34 Fairview Road in Canton, I think it's still on Zillow. You can see the pictures of the basement as it existed when they listed the house, and all the gym equipment is down there. Lucy's mama, I can't opine on this. I have no thoughts on that. I won't speculate on that, but thank you for the super chat. Rationable Cooperation. Thank you so much. I thought that was a funny name. Rationable Cooperation. Well done on the name. Kate Music Taylor, thank you for your $10 super sticker. I appreciate you so much. Effin Hippie has a request for a Jerry Garcia 4-finger palm emoji. I'll allow it. See if I can do it. KDB points out that Karen Reed and her team didn't see the autopsy photos until May. And that is when Brian Albert got rid of Chloe the dog. Very interesting too, right? How they use such distancing language about the dog during their testimony, calling Chloe it instead of she. Any of you dog owners out there call your dog it instead of by its proper pronoun? Its proper pronoun, his or her proper pronoun? Dove's House says, Dear Abby Melanie, male heterosexual here, wondering if it's okay to be experiencing unexpected feelings after Yannetti's performance in court today. I'll allow it. Thank you very much. Anybody catch up on the latest White Lotus? What? Okay, no spoilers, but what? Okay. Nico says, no spoilers, please. I appreciated that so very much because we were a little behind, although a lot of the streams were way behind because of all the technical difficulties in the beginning of the day. ShamWow says, I thought a stenographer was allowed. Isn't that the old way that can assist in readbacks? Yes. I have been told that the Madam Court Reporter that we usually see in this courtroom is doing the Turk, Dr. Harry Turk's jury selection today in the big courtroom. That's why she's down there. So we had a sub-court reporter today. And I think they made a motion for a stenographer. I don't recall if that's been granted or not yet. So is Lally now just a paper pusher for this Commonwealth? Says Will Newman. Maybe. Seems that way. It's great to see Liza Little getting her time in this trial. She's the unsung hero, says ShamWow from Canada. Thank you very much. Tanya wanted to know if there's ever been a case with third-party culprit and Bowden fence. Yep. Oftentimes they do go hand in hand. ShamWow came in again to tell Hank to read the Duck and Manual. It doesn't have a yellow cover. Orwellian Unperson, thank you for your 20. The defense should look at movements, Apple data, etc. of the 3 culprit overlaps with the movement of John O'Keefe that night. Well done. Well done, but they don't have the Apple Health data, I don't think, from Brian Higgins. Remember, he got rid of his phone, and they have very limited information from Brian Albert's phone. And that would be great if they could do that, but they don't have it because every time they made a Rule 17 motion for it, the one time actually went up to the SJC for Brian Albert and Jennifer McCabe, and it came back reversed in part. Thank you very much. Thank you for the free shipping and for all you do. Got more merch. Awesome. It's free shipping today only in the merch shop. I've pinned the link to the chat. Also, the link for the Karen Reed Defense Fund is below in the show notes. So thank you very much for that. Mudrocker points out something very interesting. Entitlement is a slur often used against strong, intelligent, successful women by weak men. Yeah, isn't it? Isn't it though? Lola the good dog. Blood collected in solo cups. Blood not able equals blood not able to be tested. What if blood was not? Officer John O'Keefe's right. Could have been a third-party culprit's blood in the snow. And it was left in an open Stop and Shop bag in open solo cups next to the murder weapon in the salad board. There's pictures of it. Put that in your snowblower and dismiss the case. Yeah, except it was a leaf blower, but I'll allow it. I know what you meant. Thank you. Mudrucker is the one who put up that quote about entitlement. Heather, a reasonable ADA accommodations, yes, for Karen Reed. Absolutely. People in the chat have said I have Crohn's too, and I can't get up and walk. It's uncomfortable. Michelle says, just want to say love you. Thanks for educating this nurse on legalese. My pleasure. And that reminds me, I'm going to be on Nurse Kim tomorrow. I'm going to be on with Nurse Kim tomorrow night at 8 p.m. So you're going to want to make sure to set your notification for that. Hard Plastic and Static Mannequin says she wouldn't be doing all this if she was going to grant the motion to dismiss. Yeah, we're supposed to have a ruling by the end of the day. We'll see. Thank you, Mandy Stone. And Michelle is here and she gives you 5 memberships. Thank you, Michelle, for your super chat and for your membership gifting. And also Melissa's a new member. No, Mr. and Mrs. Reed today. Hope they're okay. Oh, I didn't see that. I didn't notice. Perhaps they gave up their seats for other people who wanted to come into court today. I don't know. I don't have any inside info on that. Michelle, did the McAlberts not attend Officer John O'Keefe's funeral because they had injuries? I don't know. Some of them did. I think Jennifer McCabe did. Some of them didn't. I'm not exactly sure who did and who didn't. But that has been speculated. Paul says if you disconnect from CarPlay or car Bluetooth connection, your iPhone's Maps app will automatically drop a marker indicating where your car is. Well, that's interesting to know. And also, they have a lot of forensic experts that they've exchanged. No dismissal or hearing why the motions, if yes, I don't know what you're trying to say, but we don't know. What the motion to dismiss is going to be decided by end of day. And yeah, if she was going to say she's dismissing the case, why would she hear the motions? I don't know. Maybe she's trying to throw us off. Like, trying to do the deep fake, like a fake out. Mandy needs a shower after Hank speaks. Hey, it's me, he says. Thanks for the 20. My ex always said to never fight over a woman because you just might win. There's a reason he's my ex. Ooh, well done. Thank you for your super sticker, court reporter supporter. Ginger, how effective would a petition to the Attorney General Pam Bondi highlighting the lawfare and attack on Karen Reed, review FBI and other decisions? I don't think that would be effective in the slightest. Sorry, Ginger. Sorry to burst your bubble. Ex parte, not today. How can I find your song playlist on Spotify? It's linked in the show notes below. Thanks for asking. Just go to the show notes. It's right there. There's a link to it. We started a playlist, a mixtape, if you will, during the first Karen Reed persecution, and now we are adding to it. Monthy, thank you for your super chat. Fast, spinning your tires in fresh snow can, I think they meant fact, spinning your tires in fresh snow can make it appear that you're traveling distance and fast despite not moving. Yes. And we saw that when they went to put her car in the tow truck in Dayton. Thank you very much. Someone called Spanky Pee Wee Herman. He does look like him. Thank you for your super chat, Orwellian person. Does anyone remember Karen getting the carpet from 34 Fairview? I do. That was in the Vanity Fair article, I believe. That was in the Vanity Fair article, and so it has not been tested. And so we don't know too much about that. Let's look at Olivia. Let's look at Olivia's latest Twitter post from this morning, because she's on top of it, and she's usually here in the chat. And if you don't know who Olivia is, many of you are not on Twitter, but if you are, I know it's called X now, but I don't care. I'm never changing, and I'm always going to call it Twitter. Cry about it. All right, Olivia, tweeted today, earlier during arguments, or when she heard this in the arguments, if you heard Hank Brennan's argument about hosts of a radio show who spoke and met with Karen Reed discussing internet rumors of Colin Albert's alleged drug activity, his distortion of the facts probably left you with the impression that Karen Reed started said rumor and that it was only the radio hosts who shut down the rumor as being totally false. Hank Brennan's trying to argue or imply that Karen Reed spread this rumor to tarnish Colin Albert's reputation. Olivia does nothing without receipts. Here's what actually happened. Scroll below. The only problem is that in reality, Karen Reed actually went out of her way to defend Colin Albert when asked about the internet the internet rumor. Wow. She didn't have to, but she did anyway. From the radio hosts of the Greg Hill Show, following their meeting and discussion with Karen Reed, they stated, Karen Reed, was very honest with us because a big story all over the internet was that John O'Keefe had reported Colin Albert for some drug activity before all of this happened. She said that story is completely false. She said that never happened. He did not report him for anything. Funny how Brennan essentially accuses Karen Reed of doing the exact opposite of what she really did, particularly when what she really did in that instance was defend Colin Albert by quashing an internet rumor she knew not to be true. Who needs the facts when you've got Hank Brennan on your side? Well done, Olivia. Well done. And here's the video because she has receipts.
Regarding the suggestion that there was some type of feud or tough relationship, I saw on a video that there were two radio personalities, and I have the clip, who spoke and met with Karen Reed. And during the conversations, at least they relayed that there was some claims about a drug issue. And according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. Regarding the suggestion that there was some type
she's
of
got the
feud
receipts.
or
She comes
tough
also
relationship, I
with
saw
She was very honest with us because a big story all over the internet is that John O'Keefe had reported Colin Albert for some drug activity before all of this happened. She said that story is completely false.
Yeah.
People are trying to make it more dramatic and make it seem like Colin Albert would have some type of, reason for hating John O'Keefe. She said that never happened. He did not report him for anything.
No, I think
She was very honest with us because a
There you
big
go.
story all over the internet is that
Is that the clip that you had for the court, Mr. Brennan? Is that the clip that you had for the court? Because she was very honest and said, that's not true. John didn't report Colin for any drug dealing. Not true. Suze says Kate Peter started that rumor. I don't know who did. But it's interesting to me. Let's take a look at Don Ciccio. For those of you who know that I don't remember what stream it was. Maybe it was last week on Thursday or I don't know. When was my last stream on this? We talked about somebody I found on Twitter who's an artist and he does watercolors and he's been sketching and watercolor painting all of the characters in the Karen Reed trial. His name is Don Ciccio 74 and he only had 181 followers. Hang on one second. He only had 181 followers on Twitter when I showed you guys his feed and I said, you have to go follow Don Ciccio. Well, and then I said, wouldn't it be so crazy if Don Ciccio did a watercolor of me? Well, not only did his Twitter feed blow up and you guys are so awesome, but take a look. Hold on, where is it? Because of you, Chris, AKA Don Ciccio 74, which is a Godfather reference. If you know, now has 2,309 followers. Oh my gosh, he posted this today. He did a watercolor of Karen Reed. This was 3 minutes ago. Get on there, find Don Ciccio 74, show him some love. Amazing, amazing, right? Here's Judge Bev. It's from yesterday. Michael Marcy. He's got Meet some Canton cops. Meet the O'Keefes. Meet the McCabe's. Meet the other Alberts. I mean, he's an amazing artist. He wrote me the nicest email. He was so thankful. I was like, dude, you deserve it. You deserve the attention. Meet the smartest people on the stand, doctors. Here's some other Alberts. Then, hold on, wait for it. He said, thank you, Melanie Little. And he did a watercolor of me. How awesome is he? So many of you sent it to me and you were like, we want to buy this for you. And we've already worked it out. So thank you, Chris, for putting me in your Twitter feed. I appreciate you so much. Yeah, he's great, right? Go follow him. He's so talented. I love it. I feel very honored and flattered that he would do that. And also so honored and flattered that he made me look probably at least 20 years younger than I am. But thank you. That was a very kind rendition of me. So thank you to Chris. Isn't that great? His handle, you know what? I have a banner. I have a banner with his handle on it. I'll also link it in the show notes below. But it is here, Chris at Donciccio74. You guys, he even put the lip color on like you asked. It's great. I love it. I love it. I think he's on Twitter. I don't know if he has an Instagram feed. I should tell him he should go on Instagram because many of my followers are not on Twitter at all. We tend to skew a little bit older, and so many of my viewers are not on Twitter. But I should maybe suggest to him that he do some stuff on Instagram too. I've also heard some very terrible news that Meredith O'Neill's uncle was killed by a drunk driver, I think last week. And there's my prayers and thoughts go to her and to her family, and that is heartbreaking. And there's some wild body cam footage on YouTube of the woman from 3 other prior instances of her being a drunken, I don't know if she was driving during one of them. I think she was just, causing drunken behavior in Hoboken and other places. I don't know where her uncle was when he was killed. If you're interested in that case, I have some documents on it. Meredith has posted some stuff and we can go over that case. So tragic. It is so tragic. No, the girl who hit him is like a younger woman. It's horrible. The body cam footage is horrifying to watch. And these were prior instances. This is not the body cam footage from that actual incident. Yeah, it's insane. She's 32. Wow, you want to talk about entitlement? And you want to talk about a frequent police caller? I mean, the police were responding to her address all the time. She lived in a bunch of places in New Jersey. I don't know where. R.I.P. to Meredith O'Neill's uncle. Yeah, send her some love and thoughts and prayers, and heaven just got a whole lot more awesome. That's the only thing that I can think of to say when something like that happens. All right. So we did have a win today. We had one win, and the win was Commonwealth is not going to get their digits on any communications between David Yannetti and Karen Reed. The court stopped Alessi mid-argument and said, you don't even need to go any further. I'm not allowing it. They're not getting it. They're not getting it. So that was good. That was a good day. It was a good day. We heard a great argument on the third-party culprit. We read the papers before, most of the papers anyway, the opposition papers before the motion was argued in court. So we knew already what they were going to argue, which was amazing. And we heard Hank talk a lot about, how the jury should not be distracted by hearing about third-party culprits because it would be too distracting for the jury to hear about that because the Commonwealth is entitled to a fair trial. He said that their third-party culprit defense was feeble at least 5 times. He called it feeble, 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 feeble. And he wants a proffer. Meaning what? Meaning he wants all of these people to get on the stand so they can have a free deposition of what they're going to say. Again, you have their testimony from the first trial, right? No evidence of Colin throwing beer cans on John O'Keefe's lawn. No evidence of any animosity between John O'Keefe and Colin Albert, is what he's saying. The only evidence is that one time he was crossing across John O'Keefe's lawn and then John O'Keefe bought him candy. Here's the thing. The only person who can testify that pretty much is dead. And then one of them's alive and they might lie about it. So there's that. Then he went on to talk about Brian Albert and how he's won lots of awards. And so therefore we should not be able to impugn his character by saying that he has violent propensities and that he's known for sucker punching people. And there are two witnesses that are going to come in and talk about it and how he's a mean drunk and he likes to beat people up when he's drunk. He doesn't think that Brian Albert's character should be impugned like that because there's no forensic evidence that John O'Keefe went in the house. He also said that Higgins corroborated, literally said corroborated Brian Albert, and that we can't prejudice the jury with any of this evidence. 9 people testified that the guy never went in the house. He didn't say that. Those are my words. I'm paraphrasing. We should not allow the defense to just attack witnesses and distract the jury, because the last time they didn't even, he says, and I don't know if he's right on this. I don't know if anybody in the chat knows the answer to this. I didn't go back, obviously, because I'm with you, and listen to the jury instructions in the last case. But he says the defense did not even ask for a jury question. I mean, for a jury instruction on third party culprit. And so, therefore, they shouldn't be allowed to use it this time. I don't know. Seems to be his argument. David Yannetti got up and it was King David today. We got to see King David in his full glory and it was beautiful. It was beautiful. I need to go back and watch it again because the feed cut off a couple of times and I want to see if I can find a full one that went through one that didn't break up on a different network, but I didn't want to switch us midstream. David Yannetti said it's relevant. The defense is allowed to argue it. And had the police properly investigated the murder of John O'Keefe, they would have known about these third-party suspects, but they didn't. Brian Albert was a violent man and a violent drunk. He said he was drinking all day and night. He was at the hillside in the afternoon. Yeah, we looked at the one he just drew of Karen. Thanks, Janine. You can rewind a little bit to see it. Drinking all day and all night. They're both very large men. They were both liquored up. Brian Higgins was ghosted, and that's what his motive was, because he wanted to be with Karen. We then find out after the fact that he was on the phone when he said he wasn't at the phone. There was no metadata with anything they turned over. B. Albert. They listed only B. Albert on the police report, not Brian Albert, just B. Albert with the incorrect address on the original police report, which just goes to show they were trying to cover up for them from the very beginning of this case, according to David Yannetti. He talks a lot about the case law that supports his position or the defense's position, and he talked about gaslighting a couple of times too. Mr. Brennan is gaslighting. He's gaslighting all of us. He's gaslighting all of us. And he talked about the Bowden defense, about the piss poor investigation, and he said that Michael Proctor was terminated for his bias in this case. So absolutely, Bowden defense should be able to be used. If I could tell you how many spam calls I get a day from a 315 area code wanting to give me a loan, I have blocked every single 315 number that comes in. And right now it's Marcos from the funding department telling me that I may qualify for thousands of dollars in loan. Like, what? Is the do not call list a thing anymore? Does it just not exist? But I digress. He said that Karen Reed was an outsider and she was on the wrong side of the blue wall. She was on the wrong side of the blue wall. Somebody should clip that. Hank got up and started talking about the federal investigation. There were no indictments from the federal investigation. They did a thorough investigation, he said. And then David Yannetti got up and said, how is he even saying that? Why is he shouldn't even be allowed to argue that, because we have no idea what happened in the federal investigation. We don't even really know that it's over for sure. If you did not watch that part of the day, that is the most important part. And she's taken that motion on third party culprit under advisement. And then she listened to a little bit of the argument. Well, wait. Yeah. On the communications between David Yannetti and Karen Reed, and Hank got up there and said she waived her privilege. She's talking to the media. She's telling the media everything. Therefore, we should be able to get her communications. Alessi got up, made a really good argument. And he said, there's no reason, they're not giving a good excuse for the delay, that they have waited too long to file this motion. They've known about some of this evidence from 9 months ago and 5 months ago. And just because that documentary aired a couple of nights ago, he has not given any reason, Brennan, for filing this motion late. He said that the attorney-client privilege is sacrosanct, which we would all agree with. All attorneys who are covering this said it is sacrosanct. Many were split about whether or not she did actually voluntarily waive her privilege. But in the end, Judge Cannoni, in a surprise, shocking move to everyone, shock and horror, interrupted Mr. Alessi and said, I don't need to hear anymore. They're not getting the communications between David Yannetti and Karen Reed. They're not getting it. Then they talked a bunch about the jury instructions and also, the jury questionnaire, sorry, and the Welcher PowerPoint presentation, which they did not whittle down. And so on Tuesday, the first, jury selection will start. Cameras will only be on for the judge's opening instructions, perhaps the defense and the prosecution's opening statements or opening chit chat with the jury, and the cameras are going off until the trial starts. And so we sit. And here we sit. Sherry says on the dash cam at the scene, the cop on the phone regarding Karen being sectioned and says, yeah, and then we'll know where she is. Seems like an odd thing to say. Did he say that on the dash cam? I remember he's saying, I'm going to section her. But it was brought out by Mr. Reed on one of the, I think on the documentary or one of the interviews, that he had concerns that she was going to harm herself. And he is the one who called and asked that she be sectioned. So I don't know, Sherry, I'd have to go back and listen to that. Felicia says on the glare, Liz Reed said that her parents are at a doctor's appointment. Okay, thank you. Thanks, Felicia. So we don't have to worry about them. Al Dente, do you think the Bradel bar trial yesterday had some parallels to Karen Reed to remove him from representing Turtle Boy and removing Betterow? No. This, smoke and mirrors Tim Bradel bar hearing yesterday was like the 6th time. It's like it was like the 6th hearing on this exact issue from a case that goes back to something like 2002, 4, something like that. I don't know exactly because I didn't watch the whole thing. All I know is that certain anti-Karen Reed people made a big deal about it and then showed it on their stream like it was going to be some big smoking gun. And no, I think it has nothing to do with it. It's been in progress for quite some time. This is like the 6th hearing, Al Dente. But thank you for pointing that out. Lola, the good dog, says, FYI, Amazon sells butt dial expert merch. Really? That's crazy. Hi, Laura. Thanks for being here for 8 months and says I'm the #1 loyalty. Oh, you're so sweet, Laura. I love you so much. And Chastity Danielle, get to the membership. Thank you, sweet pea. Ducks in the Better Row says, I'm starting to think that grave concern is the burner phone code word phrase between Marcy Cannoni and Brennan. Well done. Ducks in a Better Row. That's a very, very interesting and well thought out screen name. I'll allow it. Galaxy Girl says, look up the Shelby Hewitt case from Canton, DCF employee who impersonated a high school student. Supposed to go to trial, but I don't know what happened. Okay, when I have time for some homework, I'll do it. Shelby Hewitt. We do know that they are picking a jury right now on the Dr. Harry Turk case. Would like to cover that live. I'm hoping Law and Crime is going to pick it up because Kevin Reddington is representing him, and he has told the judge in that case, I think it's Judge Halal, right? That Melanie Little has been covering this case on the YouTube, and she is a YouTuber with some credibility, and she's very fair. What did you say about me? That I was very fair and not salacious. And Kevin Reddington, you may recall, was the attorney for Jennifer McCabe, so that pissed her off. So we're hoping that Law and Crime covers it and that they broadcast it live so that we can also do the same. Thank you, Sherilyn, for your Cash App, who says nothing, but thank you for your Cash App. Colleen says, free Karen Reed, holy crap. Bev actually made a decision from the bench. It was in favor of the defense. Colleen, you saw it. We were there. We were there together. Thank you so very, very, very much for that. Shamrock bought a matcha latte and says, you need one. I do. I need another one. My new favorite from Starbucks, they have this lavender cold foam matcha latte that's made with lavender. It's made with oat milk with lavender infused syrup, and it's delicious. It's like drinking a cloud. It's really good. I highly recommend. Is Bev allowing Garrett Wing? We don't know yet, but we do know that, thank you, Nashley. We do know that they did turn over a report from Garrett Wing to the Commonwealth, so they can't whine about that. Thank you, Terry, for 3 matcha lattes. Can Karen's team get and use Proctor's internal affairs records? There is a motion pending before the judge to allow that. I do not think that she has ruled on that yet. I didn't see a ruling on that yet. So we're still waiting. Still waiting. That's actually a Talking Head song that is actually that is on the playlist. On the playlist. All right, so let me just check my inbox to see if anything else has hit the docket before we break for now, because we're coming back with the decision on that motion. But before we do that, don't have it yet. Let's just take a look. I'm just going to remind you that is free shipping today only in the merch shop. So in case you need some merch, I suggest you get it today. You can get your free Karen Read on the front, on the back. I went to Cancun with attorney Melanie Little. Thank the trolls for making me come up with that slogan. So there's that, and then we also have that in all sorts of other different. There's a hoodie, a zip up, and a hoodie. That's the front. That's the back, and then we also have some new merch that says it's pinned. The link is pinned in the chat. Just make sure you click the this little code up here where it says redeem. See this? Redeem expires today. Redeem. Make sure you click it before you put your stuff in the cart. And then when you put your stuff in the cart, then you will get the free shipping. Let me just show you the other design real fast. And then we'll take a break until they come back with a decision on the motion to dismiss. As soon as it gets filed, I know it will be in my inbox. We have a merch that says free Karen Read on the front, and on the back, it says we are outraged. Stay cool, stay kind, stay classy. Attorney Melanie Little. So there's that. And that also comes in several different colors and products. And then we have the old standbys. It strains credulity with Alice in Wonderland. And we also have tie-dyes in some designs like What Say You. Get your free shipping today only. Sometimes they have other sales, but I try to announce them when I can. It's not me. I don't have anything to do with the merch shop. It's Spread Shop, which I find to be better quality than the other option, which is Teespring. Sarah Berger says, my husband's grandmother in Massachusetts, when she was in her 80s, hit when she was walking and the car dragged her. She was tiny in stature, about 80 pounds and 5 feet tall. She lived because she was feisty. Oh, wow. That's a great story, Sarah. I'm so glad that she lived and that she was feisty in her 80s. Thank you so very much. All right, everyone, smash the like button on your way out. It really, really, really helps the algorithm. And also, thank the moderators for keeping the chat classy today. It is a very difficult case to cover. We had well over 12,000 people in here all day long. I think at some points we were maybe up to 14,000 people. And, we only have 80,000 subscribers, so that's a lot. Emily Baker, I think, probably had double, but I think she got like 800,000 subscribers. So we are tiny and growing and little, but we're making a big impact, in my opinion. So thank you all for being here, because it's because of you. Again, thank you to the moderators, to the cupcakes, to the replay viewers. Smash the like button on your way out, comment respectfully, do all the things that YouTube likes, get some merch if you want it. And as always, donate to the Karen Read Fund. That is also linked below. Make sure you have the notification bell set so we can come back later. Stay cool, stay kind, stay classy, stay calm. Really, it is not hard, you guys. It is so not hard. Your life will be so much better for it. I promise you. I love you with all my heart. If I don't see you soon, I'm gonna die. Peace. I will see you soon. Waiting for the drop.